Lord, item 11, my lord, I beg to mention, my lord. 11 to No, item 11, my lord, with the consent of other side, my lord, I pray for the matter will be listed on Monday, my lord. They also express some urgency.
This is just an appointment of arbitrator, madam, under section 11(6), my lord.
P. Goswami's
The
opinion.
lordship has come to the conclusion, but learned, my opposition, they have taken time, my lord.
He's not well
Let-
today, my lord.
Let it be on 15th, my lord.
15th,
15th, my lord.
all right, 15 December.
No, my lord, no problem.
Item 11 and the request made on behalf of Mr. G. Goswami. Matter stands referred to be listed on 15th of December. Mr. J. Roy, the counsel appears for the petition.
Another request, my lord, item 10.
Hmm.
My lord, item 10 has been listed wrongly under the column admission reply file. My lord, reply we have not filed. My lord, I pray for time, my lord.
Who's for the petitioner?
I'm for the petitioner, Lordship.
Any objections?
Oh, Lordship, only pray for a date, Lordship.
Item 10 on the request of Mr. H. Gupta, Studying Council NF Railway, stands deferred to be listed again on 7 January.
Yes, Lordship.
My lord, these matters, my lord,
7 January.
My lord,
Yes.
1 and 2, my lord, also, my lord, there is
Huh?
item 1 and 2 also, my lord. Reply we have not filed, my lord. Here, all reply is ready, my lord, by within this week. we
No,
have
no,
filed
we wait for 1 and 2.
1 and 2. my lord.
Yes.
my lord, these matters may be listed for motion on 12th, my lord. Because
When
here
did you
we-
file it?
Here we have challenged
When did you file it?
we filed it on 5th and 6th, my lord. My lord, here we have challenged my lord, proceedings in respect of compassionate appointment, and the matters will become infructuous on 15th, my lord. Because SLC will sit on 15th,
So when are
on
you,
12th, my lord.
when do you want it?
And
12th,
15 and 14 Saturday, Sunday, my lord.
12th, all right.
But non-payment of family pension, my lord.
Who's-
Let it be on 17, my lord. 7.
Family pension.
Yes, my lord.
For what? Admission?
Admission, my lord.
Let it come in January.
And date may be given, my lord.
January,
Any date
8th of January.
of last, my lord.
May I please? Item number 4, Madam, Mr. N. Dekama is leading the case, madam. However, madam, he got severe eye infection, madam. So he could not come to this court, madam.
You wait, we'll call up the matter. You
Yes,
wait. You ask somebody to represent.
Yes.
May I please, Your Honor? My lord, I beg to mention in listing, my lord, in orders column, my lord.
Hmm?
My lord, I beg to mention for listing in orders column, my lord.
Why?
My lord, this matter has come up 4/8/2025, my lord.
Huh.
Thereafter, not listed, my lord.
15th December.
Most of
Therefore, listing the admission matter was fixed for yesterday for listing, but not listed yesterday. Okay. Therefore, on next Friday. Okay.
Friday not possible, 11th.
Yesterday, regarding
Day
the
after tomorrow.
day after two.
Ah.
Okay.
I beg to mention one writ petition, my lord, for listing. That was listed last 13 October 2025. But due to paucity of time, the matter was not raised. So admission column, my lord. 17, my lord.
17 January.
No, my lord. 17 December.
Why?
Lordship family pension matter, my lord.
Family pension from October. What are you doing for 2 months?
Lordship,
8th of January.
my lord.
Please be the Lordship, I beg to mention for a listing of a pending writ petition, Lordship, this matter was listed in the last week along with an IA. And the main order was passed in the IA, but unfortunately, the interim order was not continued, Lordship. That's why, Lordship, any date during this week for only for the purpose of continuation of the interim order, Lordship.
All right, tomorrow.
Tomorrow, deeply obliged, Lordship.
May I please, your lordship, I beg to mention for listing of writ petition in admission column, lordship. Any date of after vacation.
19th January.
May I plead, your lordship? I beg to mention on WPC matter relating to service matter, your lordship. It was last listed on 24/10/2025.
21st January.
Much obliged.
May I please, your lordship? I beg to mention for a listing of a WPC matter, which was last listed on 28/2025. Matter is relating to The petitioner seeking relief.
21st January.
This is important, Lordship, because
Yes, matter is
petitioner seeking
important.
monetary relief for
Huh?
kidney
Huh?
transplant.
What are you praying for?
Listed
is
on
your prayer?
11/12. List on 11/12.
What is your prayer for in the writ petition?
Prayer for seeking monetary relief for
Monetary,
kidney transplant
monetary relief from whom?
for petitioner. He is not receiving his salary from last 2018.
Salary not received. All right, list it tomorrow. We'll see.
Highly obliged.
My lord, I beg for listing of a motion, my lord, filed in the last week, my lord. So it's
Tomorrow.
not being listed, my lord.
Tomorrow.
After tomorrow,
Day after not. Tomorrow or Friday.
Friday.
This is a matter, pension matter, my lord. Already government has filed it with it, so it will be listed on the 16th.
For admission hearing, we'll
Not
have
audit.
to give you a date in January. Because this week is not possible. Next week would be perhaps only miscellaneous matters.
January. This is when getting her pension for last,
Hmm?
since her retirement.
Hmm?
Yeah, petitioner has not received her, getting her pension since her retirement.
All right, 16th December. 16th December.
Much obliged.
May I please, your lordship, I beg to mention for listing one writ petition for Friday, lordship, motion matter, lordship.
All right, Friday.
Deeply obliged.
I plead your lordship. I beg to mention of listing WPC or on a service matter, and this matter was last listed on 22 September. And it was to be listed after 3 weeks, but not
21st January.
21st January.
Lordship, I beg to mention for listing two writ petition, my lord, on motion, my lord, on Friday, my lord.
Motion.
Motion, my lord.
When did you file it?
Lordship, in the September, my lord.
Huh?
September, my lord.
September matter.
Yes, my lord. Earlier it was, instruction was called for. my lord.
Then let it be tomorrow.
Motion.
May please, your lordship. Your lordship, I beg to mention for listing of WPC for withdrawal, your lordship.
Withdrawal tomorrow.
Obliged.
Wait, Mr. Lordship. Lordship, in today's list from 20 to 29, there is one more analogous matter is there, but that is not listed. And earlier it was directed to be listed on 11/9, but on that day also it was not taken up. So matter may come up in the next week, Lordship.
Which matter?
Lordship, it is not there in the list. It is not listed today. It is analogous to that series, Lordship.
Let us see what orders we pass in the series. You make a mention thereafter.
But it is not listed here. It may
What,
come.
your prayer is for listing that matter.
Yes. It is not for today in the next week or some.
So next week you are saying it is a part of the series. We do not know whether the matters will be listed next week. You want it to be listed along with the series.
Yes, Lord.
So you wait until the series matter is called up.
Yes.
Yes.
I beg to mention for listing of a writ petition, lordship, there was a direction to take instruction in the matter. This is a promotion matter, lordship. There was a direction to take instructions, lordship. Like only in regard to that the APR was
Motion
covered.
matter.
No, lordship, admission it will come on admission or orders, lordship.
So
Any date, lordship.
any date would be 9th of January.
Lordship, it may be 6th of January, Tuesday.
6th of January. Is it ready for hearing?
Lordship, it may be heard, lordship,
No,
because only the
It's not about,
instruction has to
it's
be
not about whether we want to hear it or
No,
not. It
Lordship.
has to be ready for hearing.
ready for lordship, only the
So
instruction has to be.
you have it on 7th or 9th of
Any
January.
date.
Which date?
7th.
7th, all right.
May please, your lordship, I beg to mention for listing. Lordship, there are two writ petition in admission column.
No, 7th January.
It is a lordship. Lordship, paying for listing of this matter, my lord, it was last posted on 10/11.
7th January.
Lordship, the
7
ITC
January.
suspension matter.
Yes.
Supplementary list for others, again proceed.
Yes.
May I please, your lordship?
Hmm.
In this further 2 weeks time may be granted, your lordship. Because these are very old, 2020 DLC, lordship kindly go through this.
My lord, this is a matter regarding a contempt case, my lord. 3 months of time was granted, but instead of 3 months, 6 years had been left, my lord.
It is a 2020 instructions you have to get.
Yes, your lordship.
Then, no, we are not giving you 2 weeks.
Yes.
This is a contempt matter.
Yes,
You have to
yesterday
explain
only
why the orders has not been complied with.
Yes, your lordship.
Huh.
I understand, your lordship. 2 weeks further time may be granted, your lordship.
No. No 2 weeks further time. We are keeping it on 15th December.
15, some difficulty is there on 16, your lordship.
All right, 16 December. You get your instructions, we will close the matter. At least on 16 December on a request made by MSK Foucault, Learned Counsel representing
The DC Kachar.
Deputy Commissioner Kachar. To place the instructions as directed by this court, by the last order which have been shown. Mr. Chauhan appears for the petitioner. Yes.
Obliged.
Yes.
My lord, we'll file affidavit by this week, my lord. It has been sent. But I'm just paying for small accommodation, my lord. If my learned friend has no objection.
Both 1 and 2 are similar.
This week we have file next.
Where is the agreement?
She was taken arbitration petition number 25.
Item 1.
Yes, lordship. 26 is the contract agreement. The relevant part would be at page 39, lordship.
Page
39 is a clause for the appointment of arbitration. Demand for arbitration. 64, clause 1, subclause Roman 1.
This is the same thing over and over again.
Same.
Why do you want to file repeated affidavits on the same matters? Matters are already settled.
All small
Orders have been passed. You are not
instructions.
filing any appeals
No.
or reviews.
Lord, since instruction has been received, Lord, my affidavit may be.
What
placed
instructions are required?
on record. my
There's a only thing is to that whether any dispute arises or not.
lord.
That's the only thing. Get your instructions next week.
My lord, no.
Next week.
Next week.
Or at
Can
15.
we fix a date?
15 December.
15 December.
Based on 15 December on the request made by the council for the
Lordship, also item-
respondents. Praying for obtaining his instructions in the matter. Mr. D. Deca for the petitioner. Item 1 and 2.
Obliged, lordship.
Item 3.
Lordship, may I please? Lordship, I am appearing on behalf of Mr. S. Bonik. He is on Lex court number 15, your lordship.
Mr.
S. Bonik.
Ah,
He is on Lex court number 15, your lordship. Kindly pass over the matter for a time being.
Corporation Department standing on the do, my lord. He has directed to file an affidavit. He has filed.
Where is the cooperation department? Huh? Please inform them we are calling up again at 11:30. Even if they are not present, we'll pass orders. Sare 11 মাটি দিব।
Item 4.
May I please?
Yes, what is your prayer?
Mr. Eda is supposed to do that.
Huh?
Mr. Eda is supposed to do that case, my lord. However, due to his infection in the eye, my lord, he could not come today, my lord. It may be taken up day after tomorrow, my lord.
On the request made on behalf of Mr. A. Deca, counsel for the petitioner, matter stands deferred to be listed again. Day after tomorrow, our board is full. Matter be listed again in January. Matter not to be treated as parted. Mr. T.C. Sutia appears for the respondent.
The January ballot. But
Can I pray for a date, my lord? Can I pray for a date, my lord?
Sorry?
For date, my lord.
Date, some date will be fixed. See, let it come in January. You make a
Alright.
mention if required.
Item 5.
But that was the case, my lord, release of pension date of birth issue, my lord, 56 and 66, my lord. They, some instructions are for my lord regarding the placing of the birth certificate, my lord, by them. But they cannot possibly, my lord, so my date of birth may be That was 66. One judgment I have.
Lordship, in this case, Lord, last date, Lordship directed me to submit the original record, Lordship. Some records I received, but these are all photostat copies, Lordship. So I have already requested them again, Lordship, to furnish me the original documents, Lordship.
When can we get it? When can we get it?
Lord, immediately after vacation, Lordship.
Otherwise, today I have placed one judgment, my lord, that will fully cover my case. 2 paragraphs.
The records which are called for by the earlier order dated so and so were not received. Have not been received by the standing council. He prays for further time. Let the matter be as requested. Let the matter be listed again in the month of January.
On 8/9, Lordship.
On 20 January.
Lordship.
I would like to.
Not to be treated as part of it.
I correspond for 2 years.
Mr. A. Boro for the
R. Boro.
respondent, R. Boro for the respondent too.
I did 6 and 7.
Big shop. Well, this was for telling the termination of the order, my lord. The record was called for on the last question.
I have
Yes.
received record.
Have you received the record?
Yes, I have gone through the records.
What does it say?
My lord, it is proved, my lord, because the statement of the victim girl, she said that the statement recorded under 161 and also 164 corroborated both the statement. And there is no lapse on the part of, my lord. In fact, my lord, he has given thankful to the authority that he was given the opportunity of fair opportunity of opposing it. And some witnesses are cross-examined by him and some are not. But victim girl is not cross-examined by him. He said need not to cross her. Hilsor railway stationer বেৰেকৰ ভিতৰে এটা সৰু ৰুমত সংঘটিত হৈছিল ডেট বাছ ৰেপ
Where is the impugned order? Dismissal order?
Impugned order, my lord. Dismissal order, that is page 39 to 40, my lord, page main writ petition. 39 to 40.
The trial court has acquitted them.
Yes, madam.
I have not received the order, my lord. I don't know.
Please somewhere.
Yes, I have submitted the copy, madam.
Huh?
I have submitted.
Even if the acquittal, my lord, there is no bar to, my lord, go for departmental proceedings.
The order.
Both are different proceedings, my lord.
So both are different, but how can you refuse to accept the finding of a competent court of criminal jurisdiction? It is the criminal court who will come to a finding whether it is proved or not proved.
But in a departmental proceeding, it is proved.
How?
Because
How can a proof in a departmental proceeding be contrary to the findings of the criminal court on the same issue?
the same issue, but the procedure.
It is not your case that besides this allegation, there are other procedures or fault on the part of the petitioner, or lapses on the part of the petitioner. Let us say that he was supposed to inform his superior, or he misbehaved with somebody. All these issues are there.
But the question is whether they were acquitted honorably or not.
Yes.
If it is honorably acquitted, then it is fine thing. Even though there
Where
is.
is that order of the criminal court?
Yes, my lord.
Moreover, the prosecutor has failed to.
Page 65.
Why don't you bring it on record?
I have.
It's not on record.
No, not a.
Yes, my additional affidavit, I have an.
Additional affidavit, it is on record, then why are you not pointing it out?
Yes, my additional record.
I have not received any additional. I haven't get.
Additional affidavit is there.
Affidavit. Additional affidavit not sub to me.
That's.
Huh? What of it?
That's.
It will be.
Copy of the order dated here.
It will be. Acha. Oh, yes, I have got it.
Whereas 6410, my lord, if kindly read, that is enough. Para 10.
Paragraph. In view of the above, this one, there is nothing on the record to show that a person committed offense and alleged error. Admission shows the offense. Big twist and down. This sense has been disclosed from the. That person with. No prosecutor will do and like.
Even her deposition is there, my she did not recognize the person in the dock that they committed rape.
Where is her deposition?
That is, why don't. That is page of this judgment, my lord, 62. 63 start from 61. PW1. Does not know the accused person. The last para during cross-examination.
Where is the deposition? It's not there. You have not enclosed it.
Well, her deposition.
Para 10. That the deposition evidence that the does not name the accused person. The occurrence took place about 2 years without night. On the night offense, he was roaming with her boyfriend named Lisa and he came here to see the railway station for the first time. Purchased some clothes. The station looked at people.
This is an honorable acquittal. What else? Not proved.
Of course, my lord.
Yes.
But the statement.
When was the judgment delivered?
That is, my lord, on
4/4.
The faculty proceeding was, my lord, order was.
Where is the appellate order?
24. Appellate order is there.
That is at page, my lord, appellate order.
Page 41.
41, annex 8.
41.
41, annex 8 of the petition.
What judgments you are relying on?
For a GM tank, my lord, that is I have given.
Tank.
Otherwise covered judgment by this Honorable Supreme Court, my lord. There are 30 and what?
No problem to that. It's a no sir. GM 10 case, my lord, they have mentioned one case, RP Kapoor versus Union of India, 164, 5 SS 7.
There are subsequent judgments based on this. Later judgments.
Judgment.
Mr. Sutia, what do you say?
My lord, GM 10 case, my lord, this RP Kapoor case has been discussed. That if the trial of the criminal charge results in conviction, DP, if the trial of the DP, if the trial of the criminal charge result is conviction, DP are bound to follow it against the public servant so convicted. Even in case of acquittal, proceedings may follow where the acquittal is other than honorable. So it is not said that he has been honorably acquitted, only say that the prosecution has failed to prove it. That's why he has been acquitted.
What else is honorable
That has been mentioned.
What is honorable acquittal?
Honorable acquitted, actually, my lord, he should be completely exonerated from the charges.
What is completely exonerated? What is the stage of
Exonerated,
complete?
manner, there is no any iota of evidence at all.
That is what the criminal court held, that there is no evidence. Prosecution could not
There
prove the
is
case.
no evidence, my lord. That's why. Otherwise, my lord, DP is, Department of Discipline Authority is bound to follow the judgment.
Is there, what are the charges here in the DP?
So there's a rape case, my lord. Possibly rape.
Where are the charges? Show cause.
376.
My lord, charges page 27, you will get of the repetition, my lord.
Huh?
Page 27 of the repetition charges can be found, my lord. That is
20,
27 of the repetition.
26.
27, 27.
Page, what is page 18?
Page 18 show cause, my lord.
Then
Section 1.
we are asking you about the show cause. Show cause.
Oh, show cause, yes, my lord, page 18. Show cause.
original presentation, what is? That's a good level. Criminal case only 4 PW witnesses are examined. In the departmental proceeding, the vital witnesses are there, they are not examined in the criminal case. Except the complainant. Give us the statements of the witnesses from the records.
Yes.
Statement was Joseph L. Jeffrey, the date was not recorded there. It's 36. Well, here statement of the victim girl. Can I read it, madam?
No, we'll read it. You give us the record.
yes.
You mark it and give us the record.
Oh, yes, madam.
Do you have the statement of the witnesses before
Yes,
the
yes.
departmental proceedings?
Yes, madam.
Please mark those pages and give it to us.
In the her statement, she identified two persons when they are parade. But in the prosecution witnesses, some vital witnesses are not examined. Well, I have given the ballot page wise ballot list ballot index.
Why two files?
Two case ballot. Same.
Two
same,
cases.
Yes, same, both are same.
Oh. This,
But are also same. Okay. In my list, I have mentioned all these things in which page what statement is there. 1 to 18. 18 no? 21. Control. तो हे पालतू कुत्ते हैं, पालतू कुत्ते नहीं। School नहीं। कोई बात है तो। मैं डालू something नहीं। And therefore it is very nice.
There are some findings with regard to non-following the procedure. No GD entry, no information to the officer in charge. So these are also part of the charges. You had, in your reply, you had accepted and you had represented for in your second show cause, you have requested and begged for apology.
Yes. Given an opportunity, he is thankful to Dr.
Yes, my lord, that is right, but I have also stated in favor of why this happens, my lord.
Whatever may have happened, we are not here as an appellate court. We are here to see if there is any ingredient of the charges against you.
My lord, where nothing happens, my lord, what shall I reply there?
We don't know. You have begged for apology. Why did you beg for apology? Why did you say that it was your fault? You have not filed an GD entry. You did not inform the OC who was sleeping inside.
Only this thing, my lord, happened there because at that time nothing happens. As usual courts, my lord, these are happening there, my lord.
You go through the records if you want.
Yeah, I have seen the reply.
If you have seen the reply, then why will anybody beg for an apology if nothing happened?
My lord, exactly the scenario, my lord, when this kind of happens, my lord, the lower constable,
we don't know
what the situation happens, my lord, before the officers,
but
my
to
lord.
say
No.
that there is no material in the proceedings cannot be accepted. The allegation that you committed the previous offense may not be made out in view of the criminal order, but there are other discrepancies available.
Only thing, my lord, I could not inform the matter, my lord. That is
Whatever it may be.
only thing.
Whatever it may be.
I did not inform the matter. Since the situation was there, my lord, FIR was filed, I was arrested, thereafter suspension in this way, my lord.
No. The information had to be made earlier. When you were on the duty, something happened, you are required to make an entry. There is nothing in your favor.
I admit, my lord, your lordship query is right.
There is a needle of suspicion on you.
But
that something happened.
Yes, my lord, you are right. But what exactly happened at that point of time?
In the departmental proceeding, they have recorded that the lady has identified you. You and the other petitioner.
Here she identified there when he was in dock, my lord, in the judgment, she could not identify. She didn't say, my lord, that they are not the person, my lord. She did not.
They are not sitting in appeal against
exactly, my lord.
criminal judgment.
But there is uncorroboration in between the judgment.
Departmental proceedings are not to be examined like a criminal procedure.
Yes, my lord, both can continue, but as per GM Tank, my lord, this
The GM Tank is okay, but we do not know what materials were there or not there, but here there are some materials. So, to say that there is absolutely no material is not correct, would not be correct. Taking into account the order of acquittal.
Yes, my lord, but only one thing that is I could not inform at that point of time, my lord. That is the only thing which so far, my lord.
Why he will inform, my lord? They are doing the heinous crime.
But
Why
there
they
is
will
a
inform?
provision for review. You did not avail of that. Under the statute, there is a provision for review before the government in respect of any orders passed in disciplinary proceedings. You did not avail of that, even after obtaining the order of acquittal from the trial court.
We departmental appeal have filed, my lord.
To you.
Rejected.
Only for this, my lord, the fault which I never committed, for which my service has been terminated. This is the consideration, my lord.
On 16th, 4 orders. We'll dispose it off on 16th. The records submitted before the court are kept in the custody of the court master. On 16th.
Judgment.
We'll dispose it off.
Yes.
December. It's on 16 December.
Pending item three.
Obliged.
Yes, what materials have you found out? You were asked to inform us some diary register that we are supposed to maintain.
Lordship. Otherwise, your lordship, I have already filed my rejoinder.
You have.
In that particular rejoinder, if your lordship kindly come to. I have stated that no separate registers were maintained. And in fact, your lordship, regarding the written test, our register has been maintained though, and that's a part of my affidavit, that is annexed A, page 162.
There was a written test.
Yes, your lordship.
There was a register.
Lordship.
They have all signed.
Lordship.
In the Viva, there is no register.
As per my instruction, there is no register, and in fact,
How will you know how many people have come? Who has entered? What is the record available with the department to say how many persons attended the Viva?
lordship, the record which were available, it is at page 174, annexure B, your lordship. It is the combined results sheet for Viva voice test for the recruitment up to the post of peon under the establishment of District Deputy Register of Cooperative Societies, Karimganj. Now here, your lordship, in the remarks column, the candidates which were absent were written as absent. And those who which were selected, that is here in this case, roll number 38, then roll number 1014. In the remarks column, it has been written as selected, your lordship. There are two posts for the peon under the reserve category. The persons which were absent, that is Swarup Das, then Prasanjit Nath, then Basu Kumar.
Who is Hussein Ahmed?
Respondent number 4.
Respondent 4. He was selected.
He was selected, he scored 49, your lordship.
And who is the petitioner?
Petitioner is serial number 3, Sumit Paul.
Sumit Paul.
Sumit Paul.
Yes.
He scored 42, your lordship.
Hmm.
And that apart, the highest mark which was obtained by, that is on the next page, roll number 1014, Vivekananda Das, he scored 50, your lordship. So for the two posts under the reserve category, Vivekananda Das and Hussein Ahmed were selected.
They are all for OBC.
They are all for OBC and MOBC.
And what about the written test register?
Written test register, it is there, annexure page 162, your lordship. Here, if your lordship kindly comes serially, page number 170, 38, it is Hussein Ahmed, he has signed. He was present in the written test. Page 170, serial, roll number 38.
38, Hussein Ahmed.
And on page 173, roll number 60, Sumit Paul, that is the petitioner, he was also present in the written test.
And what about Vivekananda?
Lordship, in this particular register, his name is not there because his roll number is 1014, your lordship.
Get it? Let us satisfy that also.
Lordship.
Where is where is the name of the respondent 4? Page number?
Respondent number 4, your lordship, page number in the written test, his name is reflected at page number 170.
170.
Yes, your lordship. Roll number 38, Hussein Ahmed. And the petitioner's name is reflected in page 173, roll number 60, your lordship.
You don't have the records.
Lordship, I don't have the entire records. The relevant records has been placed before me, Your Lordship.
But that serial number, that other person.
Vivekananda Das, Lordship, and then grant me 2 days time, I'll get the original records.
Get it.
Lordship.
Your case is that there are 3 candidates and there are 2 posts.
Not 3, Mal.
I mean, many candidates, but
21 were selected for.
there are 2 posts.
My case is that, my lord, the written test result were declared minor, where the respondent number 4 was shown to have cleared as general category candidate, but he was appointed in a reserve category candidate. Then another respondent number 4 and 5, whose name do not reflect in the successful candidate who has cleared the written test, but they were appointed. Then, my lord, in the just lordship, they seen that here, my lord will kindly have a look at the, and they did not deal with the allegation how they are appointed in the earlier affidavit filed on 27/2/2023. They just only said, my lord, when this came to their knowledge, some names were dropped, only a notification, a corrigendum was published on the next day, that is on 22/2014. But, my lord, when they were directed to place some records with regard to respondent number 4, they have filed an affidavit. There they take a different stand. No, it was respondent number, roll number 21 was wrongly shown as a reserve category candidate, but he ought to have been shown as general category candidate, and therefore roll number 21 name should be transferred to general category and roll number 38 to be reserve category. And thereafter, my lord, they, or with regard to this maintenance of register, I have said, my lord, I have put my signature in the, I have filed an additional affidavit, my lord, that I put my signature in the, when I was called for Viva Voce, and I put my signature at serial number 3, and 3 register were maintained. One for the reserve category candidate for men and women, one for general, and one for women.
For the purposes of Viva.
Viva, yes, my lord.
That they say no register.
But I have stated in my affidavit. When
You have said it, they have denied it.
Now, my lord, another thing, my lord, at
On
page.
what basis are we to decide this?
And my lord, in paragraph 6, my lord will kindly see in their last affidavit, page 156.
Yes.
The answering deponent further state that based on corrigendum dated 22/2024, the selected candidates in the written test for the post of peon and process server peon were called for the Viva Voce test. It is pertinent to mention herein that there are no separate register being maintained by the selection committee board for the Viva Voce test. Next, my lord, register and maintained for the written test only. Then, my lord, for Viva Voce test, board has sent call letters to the selected candidates. Accordingly, the Viva Voce test was being conducted on the respective dates. My lord, no call letter was sent. My lord, kindly have a look at page 16 of the affidavit, writ petition, my lord. Call letter. They said they have issued separate call letters for the Viva Voce, my lord.
Page?
Page 16 of the writ petition, my lord, annexed D call letter. Yes, my lord. Down below, after the columns, my lord. Successful candidates in the screening test will be called for Viva Voce. Further, you are informed that list of successful candidates of the screening test will be published on 19/2/2024 in the office notice board and leading local dailies. The successful candidates of the written test, screening test are to appear on Viva Voce, which will be held on the office of the district Deputy Register Cooperative Society, Kanimganj at so and so. No separate call letters will be issued for Viva Voce. The successful candidate will have to bring this call letter at the time of Viva Voce. And they said they have issued separate call letters. It's a contradictory statement. And another, my lord, another aspect, my lord, can you see at page the affidavit they have filed though they have not dealt with, my lord will kindly turn to page 37, affidavit in opposition filed by earlier district deputy register. Page 37, paragraph 25. My lord, this is the down below is the column number of selected candidates. And my lord, next page will kindly come, my lord, page 38. Altogether,
This is
93
for,
candidates.
this is for what?
This is for total number of, right hand side, this is for the
Written test or viva?
written test. These are the selected candidates. who has-
Written test.
Written test. Total right hand side manner for the post of peer, 93 candidates were total selected. 21 numbers for the OBC and non-OBC, my lord.
Then
And the next page, my lord, page 38. Page 38, my lord. Next page.
oh, yes.
Yes, my lord, third paragraph from the top. The total marks for peon in the written test is 30 and 15 for the vivacity test. And my lord, see the last affidavit filed by them. The maximum marks given to the candidates is 50. How come when they say that is 15 marks only?
Oral 15.
Oral 15, vivacity for 15, sorry, 15.
15.
Yes, my lord. My lord, kindly see the, just now my learned friend is on page 174. They have given maximum 50 marks. Where they have said they have 15 marks were prescribed for the vivacity test, my lord. The another candidate which lordship directed to produce the record of that person, he secured 50 marks. And the respondent number 4 secured 49 marks. How come, my lord? Even the both.
Lordship, in this case, your lordship, I have to get the clarification.
Huh?
I'll have to get the clarification from the officer.
What clarification? You call your officers, let us clarify it from them. They are feeding you with incorrect instructions. Who is the person who has filed this affidavit?
Even filed by the district deputy registrar of Karimganj. District deputy registrar.
So what is this? What kind of affidavits, contradictory affidavits are being filed? Yes. Why these contradictory affidavits are being filed?
Lordship, this is what is available in their records, your lordship, and based on that.
But it's their file through you
Yes,
as a
sir.
council.
Yes, sir.
You are not suggesting that whatever documents are given to you, you file it without verifying and understanding
It has been done as
which
per their
document has to go in. What is the context in which the documents are filed? Then, if the total marks is 15,
Lordship.
then how are you giving 50 marks?
That is clear.
Even my lord, written and test and it.
What is the written test marks?
30 plus
Written,
15, even total comes 45.
35 in respect for the post of process server peon. And for peon is 30.
How much marks did you give in written test?
30, my lord.
Written test is 30 for the post of peon and 15 for viva.
No, is there any document to show how much marks have been given per candidate?
That document is not.
Any list, any register, anything?
That has been maintained. I will inform the lordship. Marks obtained in the written test. Your lordship.
My lord, at page 65 only with regard to how much marks should be allotted, page 65, my lord, notice dated, one notice 6th of February 2024. There it is written that 30 marks for.
So that is written here in the affidavit also.
Yes.
Lordship.
But we want to see how much marks have you actually allotted. Where is the advertisement?
Advertisement, your lordship.
Page.
Page 53 of my earlier affidavit, and in fact, it is a part of the repetition.
Page 15, page 15, my lord. Annexure C.
Where have you taken this? Is there any decision taken how much marks you will be allotting and giving? Yes, Mr. Bonik.
My lord, although the challenge, sorry, although the challenge is made, please. Although the challenge is made in respect of 3 private respondents, he has to give way to 2 because he had applied for the post of peon and not for the PSP. Therefore, respondent number 4, 5, 6, whom I represent, 5 and 6 would get leeway. We are confined to respondent number 4 now. Now, during the continuance of the proceedings, my lord, what I could learn is that, and rightfully so, raised that perhaps record of the viva force was not correctly maintained. This I'm submitting as an officer of the court, not on the things. This further would lead to 2 difficulties. Whether all those who got benefit from them would have to be heard or not, number 1, or the officer coming in and stating what we have done would be enough. Now, just because as I was going through the file, I could come across a writ petition, which would have a tremendous bearing as a sheet anchor. 4453 of 2016.
Where is it? Filed by?
Filed by one Srimati Buli Bhattacharjee on the same advertisement for the post of peon, albeit she was a woman. In that case, she had filed a writ petition saying that the right to information at whatever it was sought for was not being given. And this Honorable Court, by an order dated 25th of May 2015, had directed the authorities to provide the information. Accordingly, on the 23rd of November 2015, the District Deputy Registrar of Cooperative Societies, Karimganj, provided this information. In this chat, I could see annexure, D, would be the compiled result of viva voce. So there I see there is a compiled result of viva voce, but for the women. If there is done, it should have been done. Now this takes us to the larger question. Once you provide, because it's a writ petition, or stand corrected if the annexure is wrong. If in a writ petition, the authorities, in compliance of an order of the Honorable Court, provide and furnish information to one candidate who's seeking, why do they not give the same information to their counsel who's representing in a case where my service is at stake? I'll just hand it over, Miller. Gentleman has to answer that. He cannot play with my service. I got it from merit. My reservation is not my handicap. So, of course.
So that is there. It's part of the affidavit now.
What I am on, if this gradation was, the tabulation was done, what else would be required? We fall back to the allotment of marks.
No, it's a question of their statement on oath to say that maximum is 15 marks.
Absolutely. So the 50 or 15 may be mispronounced and mistreated. I'm on not on that.
I don't know. It's quite likely that they will come up and say it is mispronounced.
I'm not on that. Maybe likely.
Instead of 15, it should have been 50.
I'm not on that. But what I'm on, when you've done the exercise, which you cannot undo, so the allotment of mark would have to be what you have decided further. So the note it would be required.
Now the consequential question, which we can put to you also.
My lordships.
Is that was there declaration or announcement of marks to be allotted during the course of this examination?
To
by
the
way of a
specific question, I need a specific reply and instruction. I could get that also. That's not a problem. But the corrigendum, which brought me within the zone of consideration, is not under challenge till date. So
no, that's
also would be bearing me.
That is okay, but
I would get that instruction.
Right now, let us dwell on this to find out.
We'll file the affidavit. We'll file the affidavit.
That the standing council is unable to help us.
That's the thing. If
why,
he takes,
why are you unable to help us? These are your department, your marks. If they are not cooperating with you, tell us.
whatever instruction has been provided based on the file the affidavit.
You are giving the same reply as if this is the first case you are appearing in court. You are a standing counsel. You know your department. You know what is the list. Why do you say that whatever instructions are given to you, are you acting as a post office? You're a counsel. You have to address the court on the issues. Get it by Tuesday. Tuesday.
Tuesday.
List on 16, is it 16th? 16th. Enabling Mr. Bordoloi, the Standing Counsel for Cooperation Department, to place before the court the relevant materials with the departments in respect of allotment of marks for written test as well as Viva. These instructions are necessary in view of the fact that during the course of hearing, it was pointed out by the counsel for the petitioner that while in the affidavit filed on which date?
212.
212. Page number?
Page number 170.
In the affidavit filed on 212.
Yes, ma'am. 174 is the table number.
174,
last page.
No, where is the affidavit?
Affidavit starts from a page 155, 154, madam.
Affidavit filed on 1912.
212, madam. Last affidavit, madam. Copy was served on me on 212. madam.
On 2nd of December.
Yes, madam.
By the District Deputy Registrar Karimganj. Although at paragraph
6.
Paragraph 6. No, not this. Where have they stated that affidavit is marks? 15 marks for Viva.
Oh,
What
yes,
you
madam.
pointed
That
out.
is at page 37 of the affidavit filed earlier, my lord.
In the affidavit.
Page 38, lordship.
This is the part of the affidavit filed on
27 to
27
2023,
February,
my lord.
not 212. 27 February 2023, filed by the District Deputy Registrar of Cooperative Societies in the District of Karimganj. At paragraph?
Paragraph 25, madam. Last part.
At paragraph 25, it was reflected. It was stated that total marks for written test was 35 and oral 50.
Now that was for PSP peon.
For the post of PSP. And the total marks for written test and Viva Bosi for the post of peon was 30 and 15 respectively. So, this appears to be contradictory to the marks which are actually allotted in Viva as is seen from the Annexure B enclosed to the affidavit dated 2/12/2025 filed by the District Deputy Registrar Karimganj. Stop. Both these statements made in the earlier affidavit and the marks shown to be allotted in the Viva, which are part of the result sheet, which is enclosed to the subsequent affidavit, are contradictory. So let the Standing Counsel clarify this position with required instructions and production of necessary records if required. So the records will also reveal the decision taken by the authorities in respect of allotment of marks for the ensuing for the said selection and appointment to the posts of PSP and peon, which was initiated by the advertisement dated
21/1/2014.
21/1/2014. Let these instructions be placed before the court on 16th of December. List accordingly.
But if I may just make a submission, subject to correction. End result all those persons who were selected and all were confirmed in service, all would be affected. Whether they have a right of hearing, I put the question to myself, my lord. If yes, then all those who come in the block, everyone from that Viva,
You give us your thoughts in writing, we will examine it. We have not decided what we'll do.
very well, because the curriculum is also not under challenge. I'm just pointing
We
it.
have not decided.
We'll get it.
We are only asking for the records to see.
Wait for,
We've not made up our mind
not sure.
to allow or reject
Gotcha.
the writ petition. Let us find out. The unfortunate thing is that the cooperation department is
That's
not
what I
properly
understand.
cooperating.
And my service has become that thing.
Yes.
Wait.
Lordship, on the last occasion, instructions were sought for in this matter.
What instructions were there?
Lordship, this is with regard to 24 number of posts, which was released in another, from another.
Some instructions were there.
Yes, Lordship.
Additional AG, who's additional AG Assam? Who appeared? Mr. P. Nayak. Where is Mr. P. Nayak? APSC, any information?
Lordship, we don't have any information. We have recommended all entire select list of them.
All right, call him. Let us wait. We'll call it up again.
Close your lordship. So on last occasion, instructions were sought for from the government.
The lordship may also peruse through a affidavit at paragraph
No,
number.
but why have we not allowed him to join in case of police case?
The lordship, he himself has actually not joined. That is what.
No, your instructions are different.
Your lordship, the instruction says the petitioner has not attended to his duties after the police case registered against him as per record. And in an affidavit also, your lordship,
Then why have we not drawn up proceedings against him?
because he's a master role worker. He doesn't
Whatever
come
it may be,
under,
if he's not joined, then why are you? Is he being paid his salary? No.
no, because he has not worked, because we have stated in an affidavit, your lordship, at paragraph number 4. If I may just take your lordship to paragraph number 4 of our affidavit.
Para 4.
Para 4.
Which affidavit is it?
Affidavit filed by the director, respond number 2. Page number 52, para 4. The deponent begs to state that the petitioner joined in service on 16/3/1992 as library attendant, master roll, and continued till 15/11/2021. And then he urged for earned leave from 16/11/2021 to 30/11/2023. Your lordship, he was arrested. And here, next page, your lordship, para 6. That with regards to the statement made in para 7 of the writ petition, the answering deponent begs to state that the petitioner has informed about his arrest through letter dated 19/1/2022 to Jyoti Bharati, Tezpur. Further, he informed the authority about his bail on 2/7/2022. And in paragraph number 7, with regards to the statement made in paragraph number 8, the answering deponent begs to say that the cultural development officer of the Jyoti Bharati was not directed to do so, as the petitioner was the master role worker. Master role employee as such doesn't have a.
No, so what do you want to do?
Your lordship, otherwise.
What is the department supposed to do? That somebody comes and joins, you pay him, somebody doesn't come, you don't join him. You don't know whether disciplinary proceedings are to be drawn. What is this? What is going on?
Your Lordship, he is a master role worker. He doesn't come under the as he is
All right,
claiming.
he doesn't come, then what
And-
what is the view of the department in respect of such employees?
Lordship, if
Do
his
you allow
services-
them to do whatever they please?
if his services are required, he'll be engaged. If his
Well,
services are not required,
Whether it is required or not.
Lordship, he,
Your,
his
according
services
to
may,
your, the instructions placed
may not be
is
required, your
that he
Lordship.
has not attended to his duties, means he has been allotted some duties.
He has been, but
Yes.
he had not joined.
He had not joined.
He had not
So
joined.
therefore, one thing is clear that he has some duty.
Yes.
You have already allotted. There
Yes.
is a need for his services.
Your Lordship, I respectfully beg to differ, your Lordship, maybe, because here there may be a need for his services, but if he,
Mr.
We-
Counsel, you are submitting on the basis of instructions.
yes, your Lordship.
We are going by your instructions. Your instruction says no dismissal order, no departmental proceeding, reason for not allowance. He has not joined his duties.
He has
Means there is a duty allotted to him.
If he has not himself joined the duties, your Lordship, then we cannot,
Duty must be allotted first.
he has to
There
join
must
first.
be a necessity for the person to go and attend to his duties,
Exactly, your Lordship.
right?
Yes.
So therefore, it presupposes that there is some work in the department where his services.
Let him join, your
Are
Lordship, then the
necessary.
department will take a call,
It
your
is
Lordship.
his case that he has not been allowed to join.
Your Lordship, let him join, because the instruction says
Mr. Counsel, he says, I went to join, I am not allowed to join.
that is not what the instructions, latest instruction says.
Lordship,
Your Lordship.
page 36 of my requisition, Lordship, where I have categorized, ask the department, Lordship, to allow me to join, Lordship.
You go and join, who's
Yes,
stopping
Lordship.
you? They,
Yes,
according
yes,
to them, that they are not allowed, you have not joined.
He had not,
Lordship,
they have not, he has
Page,
not.
page 37, maybe, page 36, maybe, looked into, Lordship, for a moment. My requisition, Farnatular to page 37, Lordship. I also got it.
What order was passed?
No order, Lordship. I went to, I submitted an application for allowing me to join. So,
All right,
Lordship-
you go and join tomorrow.
Yes, Lordship.
You come back and inform us on Friday.
Your Lordship may observe that, your Lordship.
Heard learned counsel for parties in terms of the earlier direct orders passed
Yeah,
before-
one time, okay,
by
no.
the court. The the government council has placed before the court
Correct.
the instructions received, which reflect as under the instructions received by communication dated 4th of December 2025, which reflects as under that there is no dismissal order passed against the petitioner. So there is no departmental proceeding pending against the petitioner. The reasons for not allowing the petitioner to join is that the petitioner himself has not attended to his duties after the police case registered against him as per report. So, per contra, counsel for the petitioner, however, disputes that the petitioner has refused to join. He has referred to the representation, page number
Page 37, Lordship.
36,
36
representation dated 9/5/2022. To
As well as,
submit that
so
he
at
has
page 50 also.
represented before the authorities. The director,
Yes, Lordship.
who did you refer it to? Director,
Lordship, the,
Cultural
yes,
Development Officer,
yes, Lordship.
He was
Jyoti
engaged
Bharati in Facepool.
And,
in Jyoti Bharati Testpool. He
As
was
well as-
engaged as a master role worker in Jyoti Bharati Testpool.
Yeah.
as
So
well as Lordship, page 50, Lordship. To the director also, I have submitted a application.
along with a copy to the, along with a separate application to the director also. But in spite of that, the petitioner has not been allowed to join. Mr. Bora, the learned counsel for the government counsel submits that the petitioner reports for his duties, he will be allowed to join. That's your submission?
No, your Lordship, the government will take a call, your Lordship. What?
Why are you deferring now?
Your Lordship, I'm not deterring your Lordship.
You are
because
saying
that's
that he is
my
not
call
allowed to
take,
join?
your Lordship.
He has not joined?
He has not joined, your lordship.
Then
Reason number 3.
what is the meaning of he has not joined?
He has
And the
not.
government will take a decision?
Your lordship, the representation as such is pending.
No. We are talking about your instructions.
Instructions. Reason number 3.
What is
Reasons for
reason number three?
non-allowance of joining, your lordship.
Please
The
repeat it again.
instruction
Please
says the
repeat it again.
petitioner has not joined
Yes.
and not attended to his
No,
duties.
read reason number 3.
Reason for non-allowance of joining. The petitioner has not attended to his duties after the police case was registered against him as per record. That happened in 2022.
Right. So what does one understand of this?
Your lordship, as far as my understanding goes, your lordship, from 2022, he himself has not joined.
Very well.
Yes.
Now what is the department required to do?
Your lordship, first and foremost, he is a masteral worker. He's a seasonal worker. It's not basically a he
We
was
are
not
asking
appointed
you
to
that
a
this is
sanctioned.
pastoral worker. You have produced these instructions before us.
Yes.
In this cryptic manner. So whatever you understand, you explain to us.
Your lordship, the department, if he goes there and joins, your lordship, let the department take a call as to whether his services are required or not, your lordship.
We have repeated it that these are your instructions.
Yes, your
No DP, no dismissal order. He has not attended to his duties.
Yes.
What is the meaning of that? How do you engage master role workers?
Lordship, there is no advertisement as such. Then, as and when the
As per the whims and fancies of the directorate.
Your lordship, not
What is the principle
Your
for
lordship,
engaging master role workers?
That
Under what authority?
as per requirement, your lordship,
What do you
perhaps
mean as
he
per
applied.
requirement?
He applied
No,
for a
as-
particular.
What do you mean as per requirement? Who pays for their salary?
Your lordship,
Or
as
from their
per the
personal salary they pay?
as per the appointment letter, if I may take your lordship to
Now
that
you said that as per requirement, there is no appointment order. Where is that appointment? order?
engagement order, not appointment letter.
Where is
Order.
that engagement order?
Page 51, if I. Yes,
19 lots.
19, your lordship. I'm going to the
Have you
additional-
cancelled? Have you cancelled this order?
No. I've been,
Your instructions do not reveal anything?
This is in SMS, your lordship. I'll just go to the English version, translated version. He was appointed as a library attendant at Jyoti Bharati Testpur. Under the Director of Cultural Affairs, with effect from Mr. Bora will receive a daily allowance of ₹25 only per day for each ward. So it was a need-based.
Read it completely.
The order is temporary. The undersigned may cancel this order without giving any prior notice.
Now you come back to your instructions and tell us whether his appointment was cancelled or not.
That is
From
not
your
reflected.
instructions.
That is not reflected.
That is not reflected.
That is not reflected. That is why I'm saying, your lordship, that is not for me to take a call. Let it,
That is for you to take a call, Mr. Counsel, because you are representing a department. You are
Yes.
getting instructions on the directions of the court. You act as an officer of the court.
yes,
Don't forget that.
yes, I'm doing, I believe I'm doing. that
You are
to
not
your
doing
lordship.
it. I'm sorry to repeat.
Because,
We expect more.
your lordship,
You are placing instructions before the court as if you are an officer of the government. Are you engaged by the government?
lordship, whether his services are required or not.
We are asking you to assist the court by obtaining instructions. You throw in a piece of paper with these cryptic instructions and you are unable to assist the court. Because you are unable to understand your instructions given by your client. If you wanted more time for instructions, you get your time. Take clarity. What is this meaning?
Lordship,
Which is why we have repeatedly pointed out these instructions to you.
lordship, regarding his requirement, that's only.
We don't want your interpretation. He has filed the case, you have obtained the instructions. You have to tell us how germane are these instructions with regard to the grievances he has projected. You have submitted before the court to say that he did not join.
That is what
Let him go and join. If he goes and joins, then you turn around to make a statement that it is up to the department to take a call. How?
Lordship,
When your submission is that he did not go and join,
yes,
and on the basis of these instructions that there is no dismissal order, there is no departmental proceedings pending, And you have also pointed out an appointment order, engagement order.
Engagement order.
Has it been cancelled?
No.
Then
That is what your lordship, let him join and let the department take a call. That is what I'm.
what do you mean department will take a call?
Whether his services are required or not.
We don't know. That is what you are supposed to inform us. You have given us this. We are going by your instructions.
Your lordship, then let him join. Your lordship may direct him to join. Lordship may take it up on Monday.
In
I'll
view
get
of
the-
these instructions, it is evident that the petitioner has not been disengaged from his services in terms of the earlier engagement order available at page so and so. Standing counsel, he also submits that he has no instructions, clear instructions to this effect. Under such circumstances, we direct the authorities to permit the petitioner to join in his services as requested for. Matter be listed after 2 weeks. Copy of this order we mark to the office of the senior government advocate for onward communication to the concerned department. Yes, instructions placed before the court are kept on the case record. Yes.
Obliged, lordship.
I think item 8.
Any instructions, Mr. Nayak?
Yes, sir. Photocopy, please. Take a note. Lordships, initially, stay was directed, Lordship, in respect of three post, Lordship. The Omen post has already been, filled up because of subsequent order. And the SC Simpliciter post is still vacant, Lordship. And the SC PW post is also vacant. That is one aspect, Lordship. And so far as the 24 remaining post, Lordship, how to fill up those posts, Lordship. So as per this instruction, Lordship, department has sought views of the judicial department, and that view, response from the judicial is awaited, Lordship.
So SC, disability and women are
Lordship, SC Omen has been filled up in the
filled up.
meantime.
Subsequently modified.
Yes, that stay order was.
Then
notified. But
SC
these two persons-
disability,
SC PW post is still vacant, one post.
one post.
That selection.
And SC simplicity.
SC Simpliciter.
And the petitioner claims to be a person with
I'm
He is
simple-
as simple as.
I'm a simple SC.
simple SC.
Lordship. The serial number 150 and serial number 288. These two selected candidates are yet to join, Lordship, because of the stay order.
They have not joined elsewhere.
Yes. No, Lordship. One has filed one application, but the another is not before your Lordship.
Yes, that's it. That's the instructions. What do you want to do now?
Lordship, I would like to point out just one thing. Lordship, while calculating the post of SC, they ought to have calculated on the basis of the act, which is 7%. And if we calculate on 320 post.
Wait, record, have you seen the last order?
Yes, Lordship, I've seen.
Yes, yes.
I'm just pointing it out, Lordship. If we calculate SC as 7%, then it would amount to some 24 post or 23 post. But they have advertised only 12 post, Lordship. And in terms of the PWD SC, they are saying that the PWD has to be integrated in SC. That cannot be done. That amounts to double reservation, which is not permitted under law. And in their affidavit itself, they have said that they have adjusted this post as PWD in the PWD category, in the SC category, because they are SCs, which means that they have doubly reserved. A person is PWD as well and SC as well. They can either choose either of the two. And PWD post, to give reservation, they'll have to point out whether that point has, that is a roster, in the roster point, whether that post has been reserved or not. Here they have not pointed out. And moreover, while calculating the SC post, Lordship, it has to be calculated in the entire cadre. And they've calculated only in 344 posts, and in 344 posts, they have calculated 14 posts, but they have not pointed out whether those posts are all the PWD posts are within the SC or not. Even now, if they say that this PWD has to be adjusted in SC, that is double reservation. The person is SC as well and PWD as well.
That is the horizontal reservation.
Yes, Lordship, horizontal reservation, but in PWD, there has to be according to the roster point.
No,
Yes, Lordship, in their affidavit itself, they have said that, Lordship. Lordship, I need to.
how many posts are reserved for PWD?
Initially 14 lordship. But
And-
in the select list, there were 10. Not that 1 point lordship, double reservation,
Yeah.
very short point lordship. If lordship comes to page 98 of the IA lordship, 798.
IA.
Lordship, there is an office memorandum of the state of Assam lordship. It starts from page 98 of the IA.
98.
Yes, lordship. Annexure P. Annexure, it starts from page 98. And if lordship comes to page 100. Down below, lordship will see the headline, horizontally of reservation for persons with benchmark disabilities. Now, these things will clear all the doubts, lordship. If lordship allows me to read. Reservation for backward classes of citizens, that is SC, ST, OBC, MOBC is called vertical reservation. And the reservation for categories such as persons with benchmark disabilities and ex-servicemen is called horizontal reservation. Horizontal reservation cuts across vertical reservation in what is called interlocking reservation, and persons selected against the quota for persons with benchmark disabilities have to be placed in the appropriate category SC, ST, OBC, MOBC, unreserved depending upon the category to which they belong in the roster meant for reservation for SC, ST, OBC, and MOBC unreserved. To illustrate, if in a given year, there are 3 vacancies reserved for persons with benchmark disabilities, and out of the 2 persons with benchmark disabilities appointed, 1 belongs to scheduled caste and the other belongs to unreserved category, then the SC candidate with benchmark disability shall be adjusted against the SC point in the reservation roster, and the unreserved candidate with benchmark disability against unreserved point in the relevant reservation roster. So this is the procedure, lordship. Exactly same was followed by the APSC lordship. He was selected as a PWD candidate. As he belongs to SC category lordship, he has been given position in the SC category. So that is the law. In fact, this law has been settled by the Supreme Court also. This is on the basis of the law settled by the Supreme Court lordship.
Now, here, how many posts have you kept?
Initially advertised 344. In terms of court direction, select list of 320 has been published.
Select list of 320.
320.
Right. Then
Lordship, subsequently, in respect of the remaining 24 posts, they was vacated by the Honorable Court. Now we have to take a decision whether for these 24 posts.
sorry, 344.
Initially
So
notified.
this is 320 plus 24.
Yes, Lordship.
All right.
Now we have to take a decision, Lordship. We mean the department, Lordship. Whether how to fill up those posts, Lordship, from the same recruitment or by issuing a fresh advertisement.
Their claim is in this 24 or the original?
Original 340. They participated against the original 344. And that is why department has
320 posts.
300 against 344 they applied.
Sorry? Initial
initial,
44
that was original.
originally, out of that, because of litigation, 320 were proceeded,
Allowed to.
allowed to be
point-
filled
so
up.
That has been done, Lordship.
Right.
Now
So
there
in
are
this
another
320, while it was being done,
344 minus 320, 24 are still to be filled up.
no, no. Their claim in respect of 320, what happened?
Their claim is that this last person, the last SCPWD person,
In
Lordship,
the posts which are filled up,
yes,
320.
because he is a selected candidate. He is not a selected candidate, but the
Person who, the respondent is a selected.
he is a
candidate.
selected candidate. And then
The-
there,
This selection, this filling up of the post is in regard to 320.
yes.
320
320.
posts.
Now, she has also made one submission that among the remaining candidates, Lordship, among the SC category, her position is at the top, Lordship. So if result is declared in respect of the remaining 24 posts, probably she will get a position, Lordship. For the remaining SC post, one SC post is yet to be filled up. So I'm not aware about her position in the select list, Lordship, but that is their claim, Lordship.
However, the posts that are being.
How many posts are earmarked in 344? For SC?
12.
12 plot.
However, it ought to have been 22.4 in 320.
That is.
And that 12 post has been filled up.
Nice.
We have recommended.
No, এটা বাকি আছে, আমি list
No, no, this is what is the quota, what is the reserve quota for S?
No, in the original advertisement, this
7%.
is 13 Lordship.
7%.
Huh?
In the original advertisement, SC was 13. In the select list, 12 has been.
How is it 13?
Initially 13.
Reservation.
As per roster one, yes, Lord.
Calculated as 13. However, if we consider the VAT 7%, it ought to have been 22.4, but it has been shown as 12. So they have already advertised less.
Those posts are on the basis of vacancy, I mean, roster point basis, not. So at this stage, Lordship, my submission will be as one petition is pending, Lordship, in respect of that SCPW category. Lordship may consider that case, Lordship, or, and so far as how to fill up the remaining 24 posts, Lordship.
This is listed today.
It is I is there. So remaining,
IA for vacation. So vacating petition, we'll hear it together. The core issue is that only.
I am a vision impaired. And one person is reserved for vision impaired.
So have you filed a separate writ petition or you're filing an IA?
And I love.
If you're filing an IA, we'll hear it together with the writ petition. It will require the same arguments to be made.
Maybe, but Lordship, in terms of this act, Lordship, 1% of 300, it would be 3 post Lordship, and I am the third one, Lordship. So he does not claim that he is a vision impaired or PWD candidate, Lordship. So I am stuck up, Lordship, in spite of being here in the select list.
Yes, Mr. Montov, are you ready to address today or?
Well, they were asking time for some instructions.
That instructions
time.
they have placed, yes.
All the time. So they are not coming forth with a definite instruction, I suppose. Here it appears that, kindly see, my petition from court. Here otherwise. My case is that they are going to make access appointment of PWD candidates against
the SC quota. I am SC simpliciter.
Well, we'll keep it for hearing in the month of January. Let parties, the pleadings are complete.
Pleadings are public.
But we'll keep it for hearing.
They were only asking for some clarification from their office.
No, that they've said, that person is still there in the queue.
Yes.
They've not gone for alternative.
Yeah, in fact, he has filed one IA lordship. This is 226-3 lordship. That is pending. So my submission will be lordship, I support his case lordship, as he is a selected candidate and it is more than 1 year.
No, we also support his case. He's a selected candidate. The question is, how have you determined the?
No, at this stage,
the-
lordship may allow him to join lordship, making subject to outcome of the writ petition lordship.
If we are hearing the writ petition, let us
Your
hear it.
lordship, he is a selected, that is my only concern. Yes,
Who
selected
is
candidate.
the petitioner, isn't it?
Petitioner is not a selected candidate.
Not a selected candidate.
No, not a selected candidate.
Actually, one simple submission.
Uh,
A PWD quota is specifically made for only for PWBD candidates. A PWBD candidate can compete with that other open category. But other category candidate cannot come in the PWD quota. From that count, lordship, even if the petitioner candidate is got selected, ultimately at the end of the day, lordship, he cannot come with the position of that the applicant, lordship. So in that point of view, lordship, they have partially no case against that.
so the government has followed the principle that in the cases of persons with disability, if the candidate belongs to reserve category, then it will, then it will be filled up through that reserve category.
Only for that category.
Not just reserve category. If he is general, he will eat up in general post. Lord.
We'll get a?
General post.
That's right. Whereas, petitioner, you are trying to project a case that he should be filled up in what, general?
SC simpliciter. I belong to SC. The question is whether they can fill up access post. Because someone is SC and he is applying under PWD and he was selected, can he be just posted against SC quota? That is the question.
That we have already indicated in the advertisement.
What if OM also I have placed?
The OM.
Lordship, but that advertisement is also not put to challenge, lordship, in this case.
OM
necessarily.
advertisement is not on the challenge.
What is the advertisement?
We'll continue on in January. That will be listed for admission hearing on the 8th of January. 8th.
Yes. The Lordship may see that will be hard because no further instruction or anything. Lordship will decide on the papers.
No instructions. The instructions were called for at the instance of the court.
Yes, and
We
they are not
calling for any instructions further.
yes, that is.
So
They are
we
not
keep
coming
for-
with anything concrete.
Yes, on 8th of January.
Maybe on 9th or 10th, my lord, 8th.
9th is a Friday.
Oh.
8th, then we'll have to have it on 6th.
On 6th, yes.
6th of January.
Yes, 6th of January.
Yes.
6th will be too early, lordship.
Too early.
Lordship in the third week, lordship 19, 20, 21 petition.
They are.
22nd of January. 22nd of January.
22nd.
Yes.
It may be kept the part hard, lordship.
22nd January.
He's already for further hearing us, yes, sir.
Applies, lordship.
Applied.
Lordship, here the petitioner with the Assam Rifles, Lordship, is a rifle. He was dismissed because of furnishing false documents, Lordship. The order of dismissal may be paid.
Your prayer is that the punishment should be altered.
Not only altered, Lordship, I initially my prayer is to reinstate me also. But the provision is there that that punishment can also be reduced. Lordship may come to the page 20, the order. That will clarify everything now. Order of dismissal.
Yes.
May I read Lordship? Whereas number so and so rifleman Durga Bahadur Pradhan of seven Assam Rifles got enrolled in the Assam Rifles on 19 October 2009 by producing false high school leaving certificate examination and mark sheet of 2008 issued by Board of Secondary Education Assam Guwahati. And whereas in the process of verification of education certificates with issuing authority, the Board of Secondary Education Assam Guwahati 7 Assam Rifles filed their letter so and so dated 15 May 2018. The same has been declared false by the Board of Secondary Education Assam Guwahati as intimated file number so and so. Number 3. And whereas number so and so 7 Assam Rifles was afforded an opportunity to show cause as to why his service should not be terminated on the grounds of furnishing false and incorrect information at the time of enrollment so and so. So show cause notice was issued. The next is Lordship. And whereas the number so and so, the Assam Rifles submitted his reply to the EBIT mentioned show cause notice filed letter dated so and so. The said reply to the show cause notice has been duly considered and found unsatisfactory and not absolved him from culpability of his act. So the main Lordship, they have taken account of considered my reply only. And the punishment has been given at page serial number 6. Lordship. Now, therefore, in exercise of powers conferred under provision of 11(2) of Assam Rifles Act and read with Rule 17 and Rule 22 of Assam Rifles 2, I hereby number so and so of 7 furnishing false incorrect information at the time of enrollment is dismissed. So the main they have taken Lordship that considered my reply. Now Lordship may come to section 30, punishment for Lordship of Assam Rifles Act, section 30.
Assam Rifles. File na itna? Rules, regulation, huh? Don't bandi kyo diya nahi? Pone hai dimo. Yes, rule, act.
Act, Assam Rifles Act 2006, section 30.
30. Yes.
That is section 30 is fraudulent enrollment. Fraudulent enrollment. Any person subject to this act who knowingly attempts to get enrolled or enrolls any other person who does not fulfill the conditions enabling him to be enrolled shall, on conviction by Assam Rifles Court, it is on conviction by Assam Rifles Court. In my case, only the show cause notice was issued and my reply was considered. Be liable to suffer imprisonment for a term which may extend to 5 years. Assam, if I am interested, that punishment may be up to 5 years. Or is there such less punishment as is in this act mentioned. So some less punishment can also be given. Now, Lordship, I'll take your Lordship to section 57, chapter 5.
Chapter
5, section 57.
57.
Section chapter 5 deals with punishments.
Yes.
Section 57, these are the punishments laid out, Lordship. In terms of severity, the initial one is severe and the least, that is the M, serial number M is Lordship, it is the least punishment. Lordship, section 57 says punishment available for Assam Rifles courts. Number 1 is punishment may be inflicted in respect of offences committed by persons subject to this act and convicted by Assam Rifles courts. According to the scale,
what was the punishment inflicted on you?
I dismissed from service.
Dismissal.
I have been dismissed.
Number
So,
C. Number
under
C.
C, under C. So,
Under C.
as per that section 30 that we have read just now, that some lesser punishment also can be
So
given.
lesser in terms of imprisonment. Imprisonment is at serial number B.
So that should be proved by the court, Lordship. The Assam Rifles court. In my case, only Lordship the so-called reply to the so-called notice has been considered. And
Correct.
even if there is provision in
You have admitted.
Lordship.
You have admitted that it was wrongly. It was regarding service, regarding supply of false document. You have admitted.
Lordship.
Then where is the need for a trial.
Then otherwise also the provisions under which I have been punished, the rule, section 11(2). And it says that there are other
There are judgments of this court.
Yes, that's it.
Of a division bench, perhaps of a single bench. In respect of these matters.
That's it.
Do you have it?
That's it. Division bench judgment, Lordship has passed one that leniencies it can be given.
Where is that?
That's it. That is, I have already submitted that.
You have submitted?
Yes, Lordship. Because Lordship, the dismissal after serving for 9 years without any blemish, Lordship, after or 10 years, the authorities have, Lordship, they did not raise any question for 10 years. And thereafter, dismissal will cause not only the harm to the Lordship, the person, the entire family will suffer. And even if that he will, it will have some civil impacts also, Lordship. That is, Lordship, para 9. May I read, Lordship? This was a case of CISF, but the case was of bigamy. But punishment of bigamy as in CISF is also dismissal. But taking a holistic view of the nature of the crime, that it is not the crime that is that heinous crime that will have some other impact, Lordship. So taking into consideration of families, Lordship, and other members, the condition, plight, Lordship, after his dismissal, the Honorable Court has, Lordship, though Lordship did not condone the misconduct, but Lordship, it was Lordship, dismissal was Lordship, it was not upheld, Lordship. Some other punishment was directed to be given. So here also some other punishment more in section 50 it says that some
let us see the dismissal order again.
Thank you, Lordship. Page 20.
2-0.
2-0. Serial number 4 says that considered, my reply was considered. Then serial number 6 under section 11(2) of Assam Rifles Act, read with rule 17 and rule 22. Rule 17 also says that dismissal is not only the punishment, removal, compulsory retirement, etc. can also be given. And Lordship, section 57 and 58 also says that leniency can be given in 58. Section 58 also says. Provision of alternative punishment is there in section 58. My humble submission is let the Lordship matter may be remanded to the authorities and give some Lordship alternative punishment as provided in section 58, Lordship. It says about alternative punishment.
What is the procedure for termination?
My lord, as per he was dismissed under Rule 22 of the Assam Rifles Rule 2010, my lord. And Rule 22 says, may I read, my lord?
Yes.
Termination of service on the ground of furnishing false and incorrect information at the time of appointment of enrollment. The central government or the authority, as the case may be, as specified in Rule 7, may terminate the service of the person subject to the Act on the ground of furnishing false and incorrect information at the time of appointment or the enrollment at that person in service, provided that action under this rule shall not be taken without competent authority giving the person concerned a so-called notice giving 1 month time as ground, and if any, he defends, and his explanation being found unsatisfactory. So this is the procedure for giving the false document at the time of enrollment, my lord. So by
How do you correlate with section 30?
that is, my lord, kindly come to, my lord, his dismiss, the order of dismiss, impugned order, my lord. That is page number 18. Page number 18, my lord, his dismiss. May I read his
18.
page number 18, my lord?
1-8.
Yes, my lord.
Yes.
18, no, sorry, my lord, 20, my lord. Page number 20. Clause number 6. Now, therefore, in exercise the power conferred under the provision of section 11(2) of the Assam Rifles Act 2006, deed with 17 and Rule 22 of the Assam Rifles Rule 2002, 2013, I hereby dismiss so and so, my lord. He was dismissed under Rule 22, not under Rule 30, my lord.
No, but Rule 22, you have to give some meaning to Rule 30 also. Section 30.
Section 30 is, my lord. Section 30 says, my lord, false enrollment, my lord. Any person subject to this act knowingly attempt to get enrolled or enrolls any other person who does not fulfill the condition enabling him to be enrolled elsewhere. Who does not fulfill, this is the difference, my lord, who does not fulfill the condition of and condition. But here, my lord, the rule
Also a condition.
my lord, Rule 22, my lord, says that giving the false document, my lord.
False document leading to the fact that he did not qualify for.
No, that is not, my lord, because that is his submission.
What is the
that
qualification for?
qualification is not that, my lord. Kindly say his
What is the qualification?
Lordship, at that time of enrollment, I was not a matriculate. HSLC certificate.
What is the qualification required at the time of
HSLC.
HSLC?
my lord, kindly read, my lord, page number 31, his affidavit in reply, my lord.
Yes.
Page number 31, 3-1, Roman 1, my lord. The respondent in their affidavit was submitted.
Page number 31.
31, my lord.
My reply now.
Reply.
Yes, Roman 1.
Roman 1. The respondent in their affidavit in opposition submitted that the petitioner had secured the job by producing false board certificate. As such, he was not eligible to be retained in the service. In this respect, the petitioner is begged to state that though he has submitted incorrect certificate at the time of his enrollment, but it is not the case that he does not have required qualification for enrollment continuation in service as a rifleman in Assam in as much as he has completed his secondary examination in second division, which is the required qualification for enrollment as a rifleman. At the time of his enrollment, he was not passed out, my lord. And he was not out, and therefore, due to ill advice of the Assembly, he used to duplicate certificate, which has candidly been admitted by the petitioner.
Yes, it is admitted, Lord.
Thus, it is not the case that he is underqualified for the post, my lord.
And then
And my lord,
he was put in how many years?
10 years, 9
10
years,
years.
9
years,
Yes,
11 months, 11 days.
Why did it take such a long time to detect this?
No, because my lord, I have quoted in my affidavit in opposition, my lord, because in there was an inspection in 2017, my lord. On that inspection that we have stated in our affidavit in opposition, para number 6, my lord. So inspection was done in 2007 for not only for him, for all the unit person, my lord. I have also annexed the list of all the person. This is not only for him, my lord, for all the person nominal role of verification of civil education of all the persons. That is in page number 15 of my affidavit in opposition, my lord.
Where are the punishments prescribed?
It's section 57, Lord.
Section
57.
57.
And 58 is the alternative punishment.
What about any appeals?
Appeals, no appeals.
Huh?
Appeals not filed, Lord.
You have not filed?
No, no.
Why?
Since he was dismissed, Lordship, he did not find any.
So there is an appellate
Appellate provision is there, yes.
appellate provision is there.
Yes, appellate provision is there. But my humble submission is that the punishment may be reduced, Lordship, taking into account of section 58 and section 30. If we read both, Lordship, then some leniency can be, Lordship, if Lordship. He has served the nation for 10 years also, Lordship.
You are relying on?
Lordship, 58, section 58.
58.
Section 58. That is alternative punishment. My submission is that some alternative punishment given, taking into account of his length of his service. Section 50 is.
Anything to submit on that?
My lord, because he was dismissed under rule 22, not under rule section 30, my lord. So under rule 22 prescribe termination from the service directly after giving so-called notice of 1 month, my lord. He was not terminated under section 30, my lord. So lesser permitted punishment is not prescribed in under rule 22, my lord.
So where do you say 30? Rule 22 is not subservient to 30.
Because my lord,
Point out one thing.
Yes.
The dismissal order not only says that I have been dismissed under Rule 22, it has to be read with Rule 17 also.
Yes,
Since
ma'am.
my senior friend is saying that Rule 22 and even if we don't go to Section 30 also, there are alternative punishment in terms of Rule 17 also. May I read that Rule 17?
Rule 17.
Rule 17, Clause 4, Roman 4 below. This is the person who can terminate or dismiss or remove or give compulsory retirement. So this is there, and Lordship Section 58 says alternative punishment is there, and Section 30 says that procedure that Assam Rifles Court should dismiss or that give the punishment. So Rule 17 and Rule 22
All right,
has
we'll
to
come back. What do you say regarding the judgment? I pay to Lueno. Yes.
Step 2 item for hearing item 20 to 29.
Item 20, can it kindly be taken out after some time?
No, after some time.
20, only 20. After a few minutes, madam. The brief is with my colleagues.
All right, all right. Then 21?
Yes, I am entering.
Yes, 21 to do. Yes, what has happened here?
Yes, my lord. Case 52, my lord. This one has been rejected on the ground of nervous instability, my lord. It is some cut mark is available in her hand, my lord. And ultimately she was declared unfit due to nervous instability. Case 52, my lord.
hesitation cut marks,
Hesitation cut marks.
Yes.
multiple.
Past history of deliberate self-harm, nervous instability.
What is the review? Review medical board? Where is it?
This is the review medical.
Oh, this is the review. Where is the
Original
first?
is in the top, my lord. Can you see reasons for medical unfitness in the same page, my lord? In the original medical test, my lord, 2 grounds are there, my lord.
So this is a hesitation cut marks.
Yes, that is there, but my lord, the review medical board send the petitioner to the, my lord, GMC, my lord, for opinion of expert, my lord.
Yes.
So that report is not with me, my lord. The report is with my lord in the record, my lord. If the expert
Here-
report is in my favor, then I have a case, my lord. Otherwise, I have no case.
Here it is mentioned that deliberate self-harm.
But what
Where
is the
in
opinion?
the GMC report?
Yes, Lordship.
But what is the opinion of doctor? But that is important, my lord.
What
Whether
opinion you want? Deliberate self-harm is suicidal.
Now, as per my
Yes,
assessment, my
Lordship.
lord,
And when the result was declared, then the petitioner hit her head, limbs, and started crying loudly on hit her heads on wall, Lordship. And that is all our recording is there, Lordship. CD is there, Lordship. CD is there, Lordship.
Let us see.
মই খোলাই নাই original
what is the
report the doctor and psychological issue.
So this is sealed.
Yes, that's it.
You have to open it.
I am not opening it. I have.
No,
It
this
is
is
sealed.
sealed. This is
Yes, yes,
staple.
it's
You'll have
there.
to open it.
Okay.
But take a look.
Yes.
Hmm. It's there. It is recorded in the CD. You go and sit with the government council and watch the CD if you want.
It is there, my lord, but only doctor opinion, my lord. That is, my lord.
Doctor opinion is there.
Yes, is there, my lord.
Yes.
Earlier case, yes. That is,
And earlier page, they are.
Refer to psychological assessment.
Yes, the psychological assessment
yes,
is
that is the.
earlier.
Is in the earlier page.
Yes.
But it says no psychiatric illness.
Psychiatric illness not there, but self-harm and it is difficult to appoint as a armed force in
No, but
armed force.
that finding has to be there by the GMC. It was referred by the department
Yes.
and the finding is not returned.
That opinion also not considered by the Review Medical Board, my lord.
But
And I don't know how these opinions are given in an outpatient department by just merely examining. It will require some examination.
only self-harm is a ground, lordship. That is on the basis of that self-harm cut marks on her arms, lordship. On the basis of this, RME rejected, lordship.
That is against the guideline, my lord. Guideline says, my lord, opinion of doctor should be considered.
No, this opinion of the doctor is one opinion. There are two doctors in the department who has given this
But
finding the cut marks.
This opinion, cut mark
This
is there.
opinion is not reflected there. It doesn't reflect about cut marks or anything like that.
For the cut mark, she was sent to the GMC, my lord.
But it is not
Whether,
there.
whether she has any.
Cut marks also say GMC's clinical medical doctor's opinion, lord.
Huh?
Cut marks opinion also clinical doctor of GMCHI.
This page, advice slip.
Yes, yes.
There is no such cut marks available.
The psychiatrist opinion, there is not there.
Once the petitioner sent for my lord opinion by Dr. Malad, that opinion should be considered by the my lord Review Medical Boards. Before arriving in any.
No, the opinion is, there is no opinion with regard to the cut marks.
Because of cut mark, that is why she was sent to the my lord.
Oh, Mr. Counsel, the doctor giving the opinion has to refer in the opinion that these cut marks are of no consequences. There is nothing, no reference to the cut marks.
Maybe in the my lord reference letter, my lord. In the reference letter, kindly see.
It does not rule out that these cut marks are insignificant.
But I have not examined, they have sent me, my lord, for expert opinion.
That's right, but the opinion
And the
does not.
guideline, my lord, can you see guideline, my lord, page, my lord, 105, operative person 106, my lord, in the reflection.
After the opinion, how was it considered?
In the RME, there are also doctors are there, lordship.
Then
On
why
the
did you-
basis of,
Why did the authorities send her to GMC?
for opinion.
Opinion.
expert.
Now, what is the use of this opinion if you do not consider it? Was it considered? Is there any record to show that this opinion was also considered? Or is it a mere formality of sending them for further opinion and you maintain your own stand? Is it available? I don't see it in the records.
In record, that is not mentioned.
Then, how has this been considered?
Cut marks is there, that is confirmed by the doctors of GMCH. On the basis of that report,
No.
it is considered.
Cut marks are there, you have confirmed. Then they were referred to GMCH by the authorities only.
Yes, lordship.
GMC returns no psychiatric illness. There is no reference to cut marks. How was this opinion considered? By the authority, by the review medical board. There has to be some indication that this opinion is relevant, irrelevant, not reliable, not considered. So ask them to consider it, reconsider it. This particular instructions that you have got is not the medical opinion. This is not a medical opinion. This is by your.
That is on the basis of that, we have also filed our affidavit, lords.
No, you have.
Yes.
But these records, you go through the records and
Yes.
tell us that this GMCH report was considered and then found to be not relevant or considered, and the authorities found that in spite of that, this particular defects appeared. Now you see, you have made a statement from your instructions. Do you have one more copy? No.
No.
All right, we'll give it back to you. तीन नंबर तो दिखाई दो, report to write. Report to write. See this serial number 3, what communication, what instructions they have given. On what basis this opinion has been formed?
No, this is, this instruction I have, here it is pinned up, so I have produced, lordship. After that, I have received another instruction on that, basis of.
Let us see that instruction. Same thing here, serial number 3. The same instructions. You are referring to serial number 5
Yes.
of the set of these instructions, isn't it? With the same instructions at serial number 3, what has been stated? We are remanding it back. You reconsider it, heard counsel for the parties. The petitioner presented her candidature in response to the advertisement on 24/11/2023 for the recruitment of Constable GD in CAPF's SSF and Rifleman in the Assam Rifles Examination 2023. Petitioner successfully completed computer-based written test, physical standard test, and physical efficiency test. The petitioner, according to the petitioner, she scored 89.57667 marks in the written test. However, petitioner was declared unfit in the medical examination for having a squint, SQUINT within quotes, and also on the ground of multiple old hesitation cut marks in the left forearms. So, the review medical board declared her unfit, citing within quotes past history of self-harm, within bracket nervous instability bracket closed. So, from the pleadings placed before the court, submitted in the court, and also on the submissions made by the counsel for the petitioner, the petitioner was sent for further evaluation before the GMCH by the CRPF authority in the psychiatric department. So the opinion of the psychiatrist in the GMCH revealed that there is opinion is to the effect that there is no psychiatric illness. What is that opinion? No psychiatric illness.
Yes.
By the opinion dated so and so. So this the learned counsel for the petitioner submits that in spite of the opinion by the specialist in the GMCH, the patient and the petitioner having been presented by the respondents themselves for further opinion, the opinion of the specialist in the GMCH ought to have been considered by the review medical board. The respondents have contested the matter by filing their affidavit and have maintained that due to past history of deliberate self-harm, the petitioner was rejected. So in para 5 of the affidavit, at subclause C capital, the respondents made the following averments that we extract for review. Page 111. Stop. The petitioner was therefore rejected and after being declared unfit due to the past history of deliberate self-harm. Stop that apart. There is also a further averment that extract over para E, page 111. Stop. Learned, next para, learned CGC therefore submits that under such circumstances, the petitioner cannot be enrolled in CRPF, as it would be a risk giving responsibilities upon her recruitment, both to herself as well as to her colleagues. So, the medical records have been placed before the court. The medical records reveal that the opinion of the psychiatrist shows that there is no mental illness noticed in the writ petition and stop. The opinion, however, reflects that the petitioner was presented in the OPD, the psychiatric department. Stop. The petitioner, there is no indication that the petitioner was treated. The petitioner was evaluated as an inpatient. The opinion also does not reflect any presence of cut marks and the significance thereof. Not cut marks, the old, what is it? Old hesitation cut mark. What do you call it?
Yes.
Hesitation?
Yes.
Marks or cut marks?
Cut marks.
Hesitation cut marks on the left forearm. So, under such circumstances, and in view of the clear averment that it may be some other person, but not the petitioner, who may have been presented before the psychiatrist in the GMCH, this court is of the view that the matter needs to be remanded to the department of the petitioner will report before whom? Who is to send? Who will send him to the GMCH?
The review medical board.
The review medical board will send the petitioner for a proper evaluation by a psychiatrist in the GMCH, by the evaluation by the psychiatrist shall be made by keeping the petitioner, by treating the petitioner as an inpatient, and all connected evaluation records, etc., must be available at the time when the petitioner is discharged, along with the opinion. So, any such opinion, along with the medical evaluation reports undertaken by the GMCH, shall be reconsidered by the review medical board, and thereafter appropriate orders will be passed. With the specific observation, writ petition stands closed without any further direction. Stop. Petitioner will present herself before the review medical board within
10
days.
I will give you a fixed date.
Yes.
Therefore, on 19th December.
Kindly, kindly not to mention the date, Lordship. There may be new recruitment processes going on. There may be difficulties. After within 10 days.
Yeah, within 2 weeks.
Yes.
From today. This post.
The only thing is, if the petitioner declared fit, my lord, then consequential appointment.
If after proper evaluation, the petitioner is declared to be fit, then consequential orders will have to be passed by the respondent.
After receiving of certified copy, Lordship, then we can communicate. After
Within 2 weeks,
From the date
from
of.
the date of receipt of a certified copy.
Yes, Lordship.
Obliged.
Obliged. Lordship.
May I please?
Yes, sir.
The petitioner was rejected on the medical ground, my lord. Initially, my lord, Suraksha Hospital reported.
What is the ground you are rejected?
My lord, initially, my lord, the Suraksha Hospital reported that petitioner was suffering from pilonidal sinus.
Where is that, where is that?
Annexure 6 and 7, my lord. Page,
6 and 7.
my lord.
Page number?
Page number, my lord, 39. Page number 39.
39.
40, 41.
39.
My lord.
Where is the finding of the medical board?
From medical board is page, my lord, 40, 41, my lord. Annexure 7. Unfit on account of pilonidal sinus.
Then you were, then you approach the GMCH.
My lord.
Then
Annexure 8, page 42, my lord.
42.
My lord.
Yes.
And
May I please, Lordship? In this matter, record is held by SS Roy, Lordship. He is busy in another court. Kindly record with not me, Lordship.
All right. Time being.
Time being 22, 23, 24, 25, 26.
All of them.
27 and 28, I can appear.
22 to 26.
Yes, Lordship. SS Roy appear.
All right. 27, 28.
Oh. 22 may be also be taken. 20. 27. Yeah, 20. In 20 also I will say.
Yes, tell us.
I think number 27.
Mohit Kumar.
Lordship, here the DME report is at 43, page 43. I was rejected, my candidature was rejected on the ground that initially for two counts, Lordship. Page 43.
43.
43.
Ah.
Initially on 2 counts, that is body weight, underweight,
No, we
weight
don't,
is
we are
48
not
kg.
43 oh.
Yes, and the second one is, Lordship, dental point.
43 is important point, instructions to candidates.
Page 43. Item number 27.
Which item you are appearing now?
Item number 27, Lordship.
You said 20.
20 may also I am appearing on 20 also.
We thought you were addressing item 20. 43, yes.
Yes, page 43. It is the initial medical, detailed medical examination, Lordship. Initial, that is body weight, underweight, that is 48 kg, and dental point is less than 14. So these were the 2 grounds initial. Then Lordship, review medical board, that observation is at page 45. Actually, 46 is the original, 45. Lordship, in the page 46, I forgot, this is the date, maybe it is important, Lordship. The initial medical board was of 10/10/2024. Page 43, 10/10/2024. Then, Lordship, the review was carried out on 15/10/2024, after 5 days, 4 days. That is, and the review, that opinion is, Lordship, page 45, copy opinion, unfit on account of underweight by 5 kg. So, my candidature was only, Lordship, rejected underweight. Lordship, the weight of a person is, Lordship, it's a volatile, Lordship. Lordship, it can be increased or it can be decreased.
5 kilos.
5 kilos, Lordship. Lordship,
You tell me how you can reduce 5 kilos in 5 days. I'll be very happy.
no, I'm not on that, Lordship.
Okay.
Due to stress, due to
5
journey.
kilos, half a kilo, 1 kilo, I can understand. 5 kilos means 1 kilo per day.
No, I am not saying that during these days he has reduced this, Lordship. His
That's what
weight
you
has been
pointed out.
reduced to 5 kg.
Yeah.
But main thing is that, Lordship, it can be also gained, Lordship. Subsequently, he approached the GMC also.
Of course, it can be gained.
Subsequently, he approached GMC. And in GMC, Lordship, pays 53. It was,
53.
Lordship, dated 30/11/24. The first initial was that rejection was on 15/10. Then he went on 30/11. Then his weight was 54 within the range, Lordship. So, Lordship, since now, Lordship, it is now again, Lordship,
Then he went on.
He went on, Lordship, on at the top, right top, Lordship, 30/11/24. It's 53.
Right top, 30/11.
Yes.
And these tests were held on
15/10/24, about 45 days after. So, Lordship, in Lordship, weight can be due to travel, due to stress, etc. His weight might have been, Lordship, at the time of review medical.
What does the rule say?
Lordship, it requires, he was 5 kg only, underweight by 5 kg. It was there in the, it is there in the
Page
issue
number?
note itself. It was 40, his weight was 48 kg.
Page number?
Page number, Lordship, 45. In original is 46. Underweight by 5 kg.
No, the regulations, what do the regulations say?
Medical guideline.
Medical guidelines. Medical guidelines to some medical guidelines. ये कौन से guidelines बना?
Weight proof को तो चलो।
It does. Yes.
But even after your recruitment, his weight factor is going to be a consideration for your further stay and recruitment, because weight increase will put you in low medical category.
Yes, that is there. Lordship.
And court jurisdiction is not there, Lordship. It is.
So therefore, at this stage, today, what is his weight? How do we know? He could be highly overweight.
So if Lordship review medical is conducted, Lordship, then if he comes within that parameter,
No.
then they
Review medical board conducted and found him to be underweight by 5 kilos.
5 kg. Lordship.
After 10-15 days, he
Yes,
was
he gained.
within the normal kilos.
Yes.
Now, where is the malice here? Where is the infirmity here?
Infirmity means, Lordship, that at that moment during the review medical board, due to that long distance journey, that due to stress, etc., not improper food, etc., that might have.
These are not parameters for a court to consider.
Yes, Lordship, I understand, Lordship.
Then what order can we pass here?
And it was after 5 days only they have carried out the review medical board.
We are not inclined to interfere in these matters like this. What can be done? It keeps on varying like this. It's not a matter of height.
Not Lord.
General down to size.
Unless you have contemporaneous material to show that even on that particular day, other medical authorities have found him to be within the normal weight, then it's
on that date he was not
not there. That's all.
That's it. Otherwise, also, that's it. In the affidavit, they have said that there is no jurisdiction regarding this entertainment of this liquidation.
That they have consistently held.
Liberty can be granted, Lordship, if it is granted. If liberty can be granted, to approach the appropriate forum, appropriate court of.
Which court?
Court is Patna, right?
Patna.
Then saying, Lordship, as per the Patna High Court, as per the affidavit.
Huh?
As per the affidavit, it should have been the.
RME was conducted in Patna, Lordship, not Assam.
Then you withdraw and file there. You withdraw and file there.
Liberty.
Liberty will grant
Yes,
you
sir.
heard counsel for parties. In view of the objections raised here, raised by the respondents that the selection was conducted in the state of Bihar. Where have you stated in the affidavit? The DME of the petitioner was conducted at the group center CRPF.
Point number 5.
Muhammad,
55.
and petitioner was declared unfit. No, but where did he submit his application?
He submitted application on Bihar Lordship.
In Bihar.
Applied.
Where have you stated all that?
He's from.
He applied at the time of application, he filed his state was mentioned as Bihar Lordship. That's why DME and RME was placed on that.
It is the stand of the respondents that the petitioner at the time of submitting his application mentioned his domicile state to be the state of Bihar. Stop. Therefore, the review medical board, medical examination, medical board and review medical, sorry, what is the first examination called?
Examination initial was Lordship, it was test 42A. It is Patna, his center. Though he is from Assam, but the reference was given in Lordship Patna, Muzaffarnagar and Darbhanga. And his medical was carried out.
The petitioner medical examination, detailed medical examination was carried out in the group center, CRPF group center in Patna, as per the choice given by the petitioner in his application. Stop. He was found unfit on the ground of being underweight by 5 kilos. Found to be underweight. Subsequently, the review medical board also found the petitioner to be underweight, and therefore he was rejected. The petitioner thereafter was presented before the
GMC.
Where is that?
Page 53.
From Patna, he came to GMC.
Actually, the petitioner resides from Tinsukia district. He is from Tinsukia district.
He's from Tinsukia. He preferred Bihar. He has done his medical in Guwahati. What is this? Why not Dibrugarh Medical College?
That I have no registration. He went by his.
Thereafter, the petitioner approached his High Court by, before the GMCH for review test, and it was found that he was within the permissible parameters in respect of the weight. After argument, after submission before this court at some level, the counsel for the petitioner sought leave of the court to withdraw his writ petition and urge his claim before the High Court of Patna. High Court of Patna, the state of Bihar, in view of the fact that the petitioner had given his preference for medical test in
Patna.
What is that? Composite
Hospital, not
Patna.
What do you call it? What is the term for that?
Composite Hospital, Patna.
Composite Hospital of the CRPF at Patna. Prayer made is allowed with petition dismissed on withdrawal with liberty.
Online apps.
The piece number to Mato.
I think 20.
Yes.
Review medical examination, your lordship will find at page 56. The petitioner was rejected.
Page number?
56.
56.
The petitioner was rejected saying that
he has kyphosis, which is a curvature of spine, forward curvature of spine. This is DME says kyphosis. And
What about the review medical?
review medical,
Kyphosis, Lordship.
this point number 3B, unfit on account of
Which page?
page 56. No?
56.
Yes.
56 is review medical board.
Yes, is review medical. Point number 3B, unfit on account of lumbar scoliosis towards left side. So this point number 1, reason for medical unfitness, which is found by the medical examination, detailed medical examination, DME, kyphosis. So these are two different types of deformity. Kyphosis is bending forward a little, like a hunchback, and scoliosis is bending sideways. So these are medical DME is RME is opposing DME findings, and there is in the guidelines that this is not permissible. This
Page number 57 is what you are relying on.
page number 57. Yes, this
57
difference of opinion.
57 doesn't talk about these two aspects. You
57
approached yourself or you were referred by the
No,
review medical board?
no, I was not referred by the review medical board, but since I am not satisfied with these findings of the review medical board, I went on my own, my lord, to the medical college, and I was examined thereby. Your lordship will find the advice slip at page 59. So this orthopedic surgeon there, Kokrajhar Medical College and Hospital, he advised for these X-rays, my lord. And the findings of the report of the X-rays is that 57, your lordship referred to earlier. So there are.
Now, what is the opinion of the?
The opinion is at the at page 60, my lord. 60, my lord. It is.
Is it not typed out?
Yes, it is not typed, and it is written on the overleaf of the advice slip. So the original is with me. If your lordship wants to take a look at the original. So it is this finding is overleaf, which is at page 60 over there. It reads that
what does it say?
Cobb's angle of thoracic lumbar spine normal.
No, but
the last part.
This is referred to the DOD radiology.
Yes. No, this is
seeking a comment.
Yes, this part is the first part. The last line is the opinion of the orthopedic surgeon. This Cobb's angle.
You show us the original.
Yes. The front page is the advice and the back page is the
front page is the advice. Yes, you had gone for tests.
Tests, you might know.
You have shown the reports.
Yes.
Then the doctor again refers it for comment.
Yes, and then this is one part, my lord. Comment. He asks for comment of the radiologist of the who examined who conducted the X-rays, and also his opinion is written in the last line. It is his opinion.
No, his opinion is sufficient, or his opinion has to be read with the comments which he has sought for. Why is he sought for comment if his opinion is final?
He is an orthopedic surgeon, and he, on the basis of the X-ray report, he can form an opinion.
He may have written for comments. If you come to page 57,
Yes, ma'am.
we will find the findings.
Yes,
It talks about
X-ray reports.
Huh?
This is X-ray report, my lord.
X-ray or radiology, whatever report it is.
Yes.
This is with regard to the configuration and alignment.
Yes. So scoliosis or kyphosis is the configuration and alignment of the spine, my lord. The spine is.
Then why has he written for opinion? The comment. He has some doubts. Where is that comment? Was any comment given?
No, my lord, that comment is not
Well,
here in record. But his opinion is also clear, my lord. And also this radiological reports, my lord.
he has given two opinions. The first is seeking for a comment.
My lord.
Which means that there are some queries which are not clear to him. He has sought for clarification.
Yes.
Which you have not done, or you have done and placed him, he has not given a reply. And he has given some comment.
Yes. About the Cobb's angle.
Now
That
the
he says the
question
Cobb's
is-
angle is now met.
What
So
is-
this is sufficient, my lord. Cobb's angle is the measurement of.
On what basis are you saying that? You
My
get a detailed report from him as a medical doctor. We'll see.
The X-ray report is also clear, my lord.
I am not a medical professional. I can only go by what is written here.
Yes. And also the other ground that I'm relying on is that the guideline says that there should be an expert opinion in such cases, particularly when it is
Did you place all this before the authorities?
No, my lord, there is no provision for appeal, my lord. It says the RME itself says that there is no provision
So
for.
therefore, unless you give us a proper meaning of what is the intention to seek a comment by the physician or by the surgeon before whom you had approached. Was he aware of what advice he is required to give?
It could be that this request for comment is made earlier on the date 01/11/2024. Earlier, before the X-ray was done.
The date at the bottom is also
It's
the same.
my lord.
Ah,
So
then-
the test was also conducted on the same date, my lord. So before at the time of giving advice for X-ray, he might have requested the radiologist for her comment. And this report are radiologist's report, my lord. So these reports contain the comment. And on the basis of this, he formulated his opinion, which says the Cobb's angle at thoracic.
Whatever is formulated, it is not clear. You are unable to explain. You are trying to interpret the opinion of a specialist.
I'm just making a submission on the basis of what shows.
Don't know. We are not convinced. Unless there is a clear opinion that there is no deformity, then we can confront them.
Cobb's angle normal means that there is no deformity.
You show us from some authority that what is the meaning of Cobb's angle. What is Cobb's angle?
This is a unit of measuring the curve of the spine. So it is that 1 to 20 is mild.
No, this is not sufficient. This will not be a proper manner to dispose of a matter like that.
And there are other grounds also that without seeking an opinion from the expert.
Not
because
necessary.
It needs
That is not mandatory. Only when there is a difference between detailed medical examination, review medical examination, if there is a difference or there is a doubt, they will refer. Here there is no doubt. Both the medical examinations.
RME, my lord. RME says Cobb's angle. At point, kindly come to page 56, my lord. Point 2, brief of review medical examination and finding. It says that X-ray whole spine reveals Cobb's angle 56 degree. But this expert opinion is saying that Cobb's angle is normal at page 60. The contrary view, slowly. And your lordship has allowed a petition on the
What,
basis of
what do the
contrary
medical
views.
reports say?
Yes, the COPS, there is a COPS angle 56. It may be normal for general people, lordship, but for a armed force, it to appoint it as a police constable, lordship, it is not normal, lord.
What is the normal range?
57.
What is the measurement of, insofar as you are concerned, arrived at by the doctor?
This medical college doctor didn't write.
Examine.
But these X-ray reports, everything is showing that his
That
spine is
COPS
not.
angle is not there.
What is the normal degree?
Yes, this is not here, but normally it is up to 20 degree is taken as mild, and but it is not there in the guidelines. Also not there, and this is also one of the issue that I'm relying on a Delhi High Court judgment to say that, my lord, that it should be there from the RME or DME, that which is the normal parameter. It is not there, so Delhi High Court says that this is a incomplete
But
report.
you have on your own approached a medical professional
My lord.
who in a cryptic manner says it is normal.
Fine.
What is normal? And how abnormal is 56 degrees?
Yes, that is,
Then
that
you
is there.
may
but
not have. you
normally
may-
56 is severe.
You may not have explained to the doctor concerned for the purpose of using the certificate.
This
Therefore, they have given a medical certificate.
so this his advice slip first state that came for medical examination. So the whether he is normal or not in terms of his spine, that was the purpose of the examination.
It is not reflected here other than saying it's a Cobb's angle at so-and-so spine normal. What is the normal parameters?
It is not here from my doctor, and it is also not there from the respondent side, my lord.
Then what
And
can be done?
that is my submission is that since one of the I could
No,
take that
unless-
they should also mention what is the normal degree.
That will be known to the medical professionals internationally.
Yes. So
If the doctor at Kokrajhar would have said no, 56 degrees normal, or they would have said that normal is between 40 to 70 degrees or 60 degrees, we would have accepted 56 degree to be normal. That range is not, that parameter is not mentioned.
Yes, this is not mentioned. Not mentioned. But the normal parameter is way below 50, 56 or 50. This is not there on the record, but this is known to the medical profession.
All right.
And
but
I have inquired.
They have not indicated that what is the degree
Yes,
in the opinion.
yes.
Then it is also difficult for us to understand.
So another examination, that is what I'm praying for.
Another examination by whom?
By the review medical board, because
On
there
what-
is this
On
contradiction.
what ground? On what ground?
This is what this contradiction, and also they didn't mention what is the normal parameter, and also this expert opinion was not taken.
All these were available before you at the time of advertisement. You had participated. And now, after being rejected, you cannot turn around.
And he is
say
also,
that
my
this
lord,
clause is not.
this kyphosis, scoliosis. This is a normal view. Any layman can say that somebody is hunchback or not. And if your lordship personally see that he is straight like that, so your lordship may call for personal
Why
experience.
we will not call? You are entitled to go and get a medical report if you want. Go and get a medical report.
My lord,
Who's stopping you? You take this back.
Yes. And then medical report they may consider.
No, first you get a medical report. We are not passing an orders like that. We are dismissing your petition.
So your lordship is keeping it pending and meanwhile
We would
allowing
like-
us to
we-
get a medical.
We'd like to dismiss it and close it.
No, so I'd seek your lordship's leave to allow us to get a medical report meanwhile.
That will not be proper. We will close this matter. We will permit you to go for a medical examination, and then if
So that, with the direction that they may consider this.
yes. But then we do not know when will you get, what report is there. It can't be so vague.
So that's why I'm praying that keeping it pending, my lord. Your lordship may allow me to.
Matter
get
be
a result.
listed after 4 weeks, enabling the counsel for the petitioner to place on record sufficient medical records in support of his contentions. List accordingly, MSS Burla for the learned CVC for this respondents. And what other matter you have? 28.
27 and 28.
27, we have
is
done 28.
Yes, lordship.
I know, pleasure.
So 28 tomato officers.
Until 28. This one, Pradhan.
27 হৈ গ'ল।
27, which matter did we do it? It was
27.
27 হৈ গ'ল। Dismiss.
Huh?
27 dismissed.
27.
27 was dismissed. Yes, lordship.
So it is 28 now.
আপোনাৰ 28.
28. Tell us.
My pleasure.
Yes.
I was, the rejection order was on page number 23. I was rejected on the ground of dextrocardia and citrus invertus. That means my whole organ, internal organs on this side, which should be in left side, but all organs are on right side. Only basis of that reason I was rejected.
Is it a ground for rejection?
Yes, lordship.
But I have, after the, I was examined on the School Medical College by MDs only. No expert opinion was there. That's why I have decided to go to GMC, which is on page number 37. And the opinion was that normal 2D echo was there. I've done normal 2D echo, which is on page number 38. On the Department of Cardio and Neuroscience Center at GMC, Cardiology Department. And the opinion was like that. The patient is fit for perform with regular activities.
You are not performing regular activities. You are performing specialized activities.
Specialized. But there are various instances there where.
So kindly see page 39. See the first opinions, first advice.
Yes. That's it. No active intervention required from the cardiology side.
Your heart is all right, doesn't require intervention.
Yes.
That is the opinion. It doesn't say that it is on this side, that side, or because of this side, you are perfectly normal. Doesn't say that.
My lordship, my point is that although the patient is that GMC is said that although the patient is fit for performing the regular activities, how can they know that I cannot perform in the extreme conditions?
Where is that regulation again? Rejection? Ground for rejection? Is it here
In the affidavit?
It is in our affidavit, Lordship.
In your affidavit?
Yes, Lordship.
General grounds for rejection.
57.
Huh?
57.
57.
Yes, page number 57.
Serial number?
3. Indication of valvular or other disease of heart. Dextrocardia is also mentioned by his doctor, medical, Guwahati
I have
Medical
admitted I
College.
have dextrocardia and Saccharine inverters.
No, no.
It is inverse, yes. Like
Where
that.
does it say that this is a disease, this is a ground for rejection?
Indication of valvular or disease of
No,
heart.
this is valvular means you have some disease in the valves, heart valves,
Yes, Lordship.
or other diseases of the heart. Dextrocardia is not there.
Yes, yeah. Medical opinion is there, Lordship, in 56 page.
Medical opinion, too, there is no opinion.
Medical opinion is there, Lordship.
But there is no mention in the year. Page number 57.
Kindly see page 55 and point 3, Lordship. Point 2 and point 3. Dextrocardia is a rare condition in which the heart is located in the right side of the chest instead of normal position of left side. Number 3, situs inversus is the condition where there is incomplete transposition of thoracic chest on bracket chest or abnormal organs, thereby may lead the possibility and potency to develop complications during extension, exertion and vigorous movement and exercise.
It is only said may lead. It is
May
not a-
lead, Lordship, hardship posting are
can
also
do that.
there, Lordship, and training
I
also very tough and hard, Lordship.
I am ready to go to the extreme condition examination if court.
He may go, Lordship, but it is
And there are various instances that there are various my seniors are there who are working properly in the extreme conditions in various departments of the
There also
armed force.
dextrocardias.
Yes, armed force. Dextrocardia and situs inverters.
They're also having the
Yes.
same condition.
Yes.
Then
Various, I can also provide the list of such.
provide it.
It may be take one more date.
You provide it.
There are various instances.
So that was your primary evidence to show that people of this condition are working.
I have one senior who guided me. He is also working on such under such conditions. He is a a senior person.
let him bring that on record, Lordship. Yes, I will.
Then
I will take instruction on that.
you'll start taking action against that senior for guiding him. Then you'll find ways and means to throw him out.
I am extremely fit.
No,
and
but
I can perform any action.
rejections are on the ground to decide whether you can participate or not. Whether you can sustain yourself, but you are giving a textbook information that these are the complications which may happen, but this person may not happen.
May not happen. May not. That's why I'm asking.
If happened, then it will be difficult for them.
No, but it can happen to anybody. Even your chief medical examiner, God forbid, may suffer a heart attack. Yes. Does it mean the person is unfit to be in service?
Yes, then we can.
Unless there are cases where he has a congenital heart disease and is not taking medical advice.
When normal person cannot.
You
move.
bring that information. Heard counsel for parties, the matter stands deferred at the request of the counsel for the petitioner, enabling him to bring on record particulars with regard to personnel who are engaged in discipline force, having the same medical condition as the writ petitioner, namely what is called
Dextrocardia situs inversus.
dextrocardia with situs inversus within quotes. The counsel for the petitioner waits for 4 weeks time. Prayer allowed is again after 4 weeks. MSS Borua, then at CGC represents the respondents. Yes.
God bless.
Nice. Huh?
Till 22.
Yes. Yes, where is that medical? Detailed
Page
medical
42.
DME report.
Page 38.
No, DME report. Detailed medical.
Page 42, madam. Annexure 8.
42 is 42. Review medical board.
Review medical board is Malad. Annexure 7, page 41. Is open that Malad, the petitioner is suffering from pulmonary sinus. Malad.
Is it a ground for rejection?
Yes.
Page number 55, serial number?
55.
Seven. G put color. Huh? 66.
Ground for rejection?
Not.
Where is it?
Lordship, I'm giving Lordship. Para six, Lordship, that 21 Lordship. Other, as per that rejection refer para 6, subpara 21, para 13 F.
So he is what sinus?
Lordship.
Pilonidal sinus.
What is that? It is not here.
As per rejection list, it was refer para 6, subpara 21. Para 13. Lordship, it's come, as per this rejection list, it's come under 21, Lordship, para 6, subpara 21.
Where is that? Is it enclosed here, the entire regulation?
Lordship.
Do you have a copy of that?
Yes, Lordship. Yours. Page 12 can be seen, Lordship. Page 12. Page 12. Nose and sinus and learning. Nose should be carefully examined. That examination is refer in this.
No. This is not nose sinus. This is not nose sinus.
Tell me. His review was done in other diagnostic center, Lordship.
You come to page 39.
My lord.
This is done by whom?
Annexure 6.
This was done by the private, this was, we have referred lordship.
Suraksha Hospital is the private.
We have referred lordship.
You have referred. You'll have to send it to the GMC for proper evaluation. You come to page 39. Impression.
Lordship.
Page 39, impression.
Normal works. Lordship, 39.
39.
Present MRI reveals.
You come to the end. Sizable fluid collection.
Lordship.
This is perhaps the ground on which it was rejected.
Lordship.
They have relied on this particular info, what is this? Report.
Lordship.
Isn't it?
Lordship.
Now you come to page number 42. This is GMC. There is no fluid collection shown. You read the first line.
The study reveals a blind ending sinus, a tract in the gluteal cleft and intact.
Then come to the second line, no diffusion,
My lord.
restriction seen. Then the last line. Heard, we are sending it back. Heard counsel for parties this the petitioner before this court, on this ground that the detailed medical examination revealed that the petitioner was found unfit on account of pilonidal sinus, which was also the view of the review medical board. So it appears that the detailed medical examination and the review medical examination relied upon a diagnostic report in respect of the writ petitioner issued by a private diagnostic center within both Suraksha Diagnostics, where the impression reflected in the report is as under page number 39, bold extract. Subsequently, the petitioner, you went on your own to the GMC, presented himself to the GMCH, where the report of the GMC reveals as under. A good report to the page number 42. Stop. Perusal of the same reveals that there is contradiction between the findings by Suraksha Diagnostics in the diagnostic reports, as well as the findings by the GMC in their diagnostic report. So, the Suraksha Diagnostics was conducted on, report was given on 28th of September 2024, and the GMC report was issued on 17/10/2024. Stop. Therefore, time gap, the time between these two reports is not It's not unreasonable. So it appears that this report could not be placed before the review medical authorities as there is no provision in the selection procedure prescribed. So the regulation which lays down the guidelines, the guidelines which lay down the grounds for rejection of the guidelines for recruitment, medical examination in CAPF and Assam Rifles, revised on May 2015, lays down general grounds for rejection. Stop. Under clause 6. Stop. You are referring to which ground?
21.
21. The learned CGC has referred to clause 21, subclause 21 of clause 6, to submit that the petitioner's case was rejected under this subclause. So, whether the medical conditions stated to be suffered by the petitioner, stated to be present in the petitioner, would be included in other anorectal diseases is not specified under clause 621. So, it is a decision to be taken by the medical authorities of the CAPF, of the CRPF. CRPF, is it?
Lodge.
CRPF. So, under such circumstances, in view of the contradictory medical opinions by the private diagnostic center and the GMCH, this court considers it appropriate to remand the matter back to the respondent authorities to examine the petition by referring to specialists if the need so arises, and thereafter pass appropriate orders. Stop. The examination will be conducted by the review medical board, and thereafter, if it is found that there are no abnormalities present, then consequential orders in respect of selection and appointment of the writ petitioner should be issued. So, any such opinion rendered in terms of the directions, copies thereof will be served on the writ petitioner. Stop. Writ petition accordingly stands disposed of. With the above direction, the directions contained be carried out within a period of 30 days from the date of receipt of a certified copy of this order.
23.
May please, your lordship.
Yes.
My lord, here the DME report is at page 20, my lord. Here the scoliosis of spine, that is lateral deviation of dorso-lumbar spine. And the RME report is next page, my lord.
Where page?
Page 20.
20. Yes.
Scoliosis of spine, like lateral deviation of dorso-lumbar spine. So she was declared unfit, and in the RME also the same
We
report.
had passed an order regarding this. Which item is it?
27, not passed. Is directed to item number 20. Hypothesis and
Directed to obtain instructions.
Yes.
Yes.
Here, my lord, there is the petitioner has gone for medical examination, GMCH, my lord. So there, my lord, the findings is at page 22, my lord. in the orthopedics department. No no scoliotic curve appreciated. Patient is fit to do regular activities. No bony abnormalities can be appreciated. So, and it is signed by medical officer or
Where is that report?
page 22, my
Where
lord.
is that X-ray report?
This is the opinion I have annexed, my lord.
No, the X-ray report is enclosed.
On the basis of the
You
yes,
produce the X-ray report.
X-ray report is. I have only annexed the my lord opinion part. It is here in my file, my lord.
What is the, where is the medical, this thing? It must have been done by some diagnostic.
Lordship.
Yes, ma'am.
Is it available here?
Yes.
What does it say?
It says Lordship. Impression mild lumbar scoliosis toward left side.
No, that's the opinion we have seen.
No, Lordship.
And my lord, this is the original one, my lord. And here it is stated that X-ray is attached. That is the X-ray plate, my lord. It is here, my lord.
It says mild.
Lordship.
Mild.
Lordship.
So is it a ground to reject?
As per page 56, Lordship. Is page 35, Lordship. Presence of history or spondylitis or other presence of history or any condition including but not limited to joined with or without objective sign prevent the individual from successfully following a physical activity, vocation, or that it is associated with local or referred pain to it. On that ground, we have rejected it.
What is the effect of this? What is the meaning of this?
Chip.
To the mild lumbar scoliosis to the left side.
Well, left side, it was bent. Left side. Lordship, in the guidelines, page 31, the picture is given, that left side.
This is who presented? Did you go on your own or you were sent?
On my own, my lord.
In GMC, they own, and Suraksha, we have sent it.
As per GMC, my report, there is no, my lord, signs of such abnormalities. As per the X-ray report given by the orthopedic surgeon.
Yes, what is to be done?
There are two contradictory views are there. Lordship, others has sent it.
No, like, we are remanding it back.
Lordship.
We take back the records.
Lordship.
Reminder. Poliotic. Right. Right, as per the diagnostics reports relied upon in the DME and RME. Petitioner was rejected on the ground of, was declared unfit on the ground of scoliosis of spine.
Next.
And lumbar scoliosis towards left side. However, subsequent evaluation done at the GMCH revealed that there was no bony abnormalities appreciated and no scoliotic curve was seen by the specialist doctor. The such circumstances remanded. Yes.
Blood.
Remanded.
24. This is also scoliosis, kyphosis, one of the results. Lordship will find this DME report at page 52.
Page?
52, 52.
Type O, what is
52? This unfit due to reason mentioned below. The first is accessory tragus and second is kyphoscoliosis spine. This is DME, and you will find the next page. Page 53 is the RME, review medical. So here also at point 2, the right accessory tragus. This is a small harmless growth on the ear. Accessory tragus.
Where is that?
Is
page number?
Page number 53.
53.
Yes. This is RME, review medical examination. Point number 1. 1. Right accessory tragus. Point number B. This is kyphoscoliosis. Spine. These are the two deformities found. But this accessory tragus is not on the list of ground of rejection. It is not there in the guidelines. And this kyphoscoliosis, the Lordship will find that at point 3B, where the final opinion is given, it says final opinion. Unfit on account of kyphoscoliosis, CT spine done and found mild dexteroscoliosis, cervical spine, Cobb's angle 12.3 degree. So this is mild, admittedly. And in the medical,
What is 54 and 55?
page, you know,
54, 55, 56. Why 3 reports?
these are X-ray reports, my lord. X-ray reports as per the orthopedic surgeons of the Kograjar Medical College.
All
where I
three.
went.
All 3 are X-ray reports.
X-ray reports.
Why 3?
Because the doctor advised for 3 X-rays. Your lordship will find the advice slip at
On the
page
same day.
57. Yes,
On the same day.
on the same day. Advice slip at page 57, my lord, where 3 X-rays were advised by the orthopedic surgeon of the Kograjar Medical College. And accordingly, X-rays were done and it was found normal. Everything is normal. At page 54, it says, impression says unremarkable radiographs of the lumbosacral spine. And these are parts of spine, my lords. The cervical spine. The second report at page 55 is radiographs of the cervical spine. And then the third report is thoracic spine. On the basis of these reports, the orthopedic surgeon gave his opinion, which is at page 58. Says clinically and radiologically no spinal deformity seen, no active intervention needed at present. It is categorical opinion, right? Page 58.
Yes, respondent.
And also as to the
Appears to
accessory
be
trigger.
another case of contradictory.
Contradictory.
On the next page, that is page 59, it is the medical opinion of as regard to the accessory tragus that was taken as a ground. It says no surgical medication intervention required. Patient is presently fit for defense job.
Page number?
Page number 59. This opinion is given by the professor and head of the department of Fakhruddin Ali Ahmed Medical College. Categorically says that no surgical medication intervention required. Patient is presently fit for defense job.
That is not relevant. You're rejected on scoliosis.
And also this this is ENT.
Accessory.
ENT in respect of the accessory tragus. This opinion is in respect of the accessory tragus.
But the rejection is on 2 grounds.
Yes. The opinion at page, my lord, 58 is in respect of the
Why different opinions from 54 to 56?
The 54 is, my lord, X-ray report. And 55 is also X-ray report. There are 3 X-rays.
I know, I'm asking you why the opinions are different, findings are different.
No, my lord, not different.
Read it and tell us.
Different parts.
No, every report says that unremarkable radiographs. First report says the unremarkable radiographs of the lumbosacral spine. It was the X-ray of lumbosacral spine. And then report at page 55 says unremarkable radiographs of the cervical spine. And the report at page 56 says unremarkable radiographs of the thoracic spine. So the 3 parts of the spine. For details, the orthopedic surgeon advised for 3 X-rays for getting every details on the spine to rule out any deformity.
All right, so it has to go back.
Not-
Also remand, huh? Right, DME, RME rejected him on the ground of 53 to something. 53 is accessory tragus and scoliosis. 53. Hmm? Subsequently, petitioner presented himself for evaluation before the Fakhruddin Ali Ahmed Medical College. Sorry, Kokrajhar Medical College Hospital for evaluation of his spinal deformities. There were 3 X-rays conducted. In the X-ray report for the lumbar spine, the findings are so and so, so and so, with the impression so and so, page 54. In respect of the cervical spine, the findings with the impression are so and so, 55. In respect of the thoracic spine, the findings along with the impression are as under. Page 56. So thereafter, the petitioner also presented himself before the Fakhruddin Ali Ahmed Medical College Hospital, before the ENT OPT. Stop. The treating physician opined that no surgery or medication or intervention required. Stop. Under such circumstances, this court is inclined to remand this matter back, directing a review medical examination of the opinions rendered by these by the civilian authorities. So, if any reference is required to be made for further examination, the CRPF authority may undertake to do so. Exercise be completed within a period of 4 weeks from the date of receipt of a certified copy of this order. Disposed.
25. Here, my lord, petitioner was rejected on the ground of jaundice.
Jaundice.
Having jaundice.
Jaundice.
Yes. The lordship will find a DMA report.
On the date you suffered from jaundice?
Yes. No, my lord. There are contradictory reports are there also.
There are-
Jaundice is not a ground, my lord. Jaundice is not a ground of rejection. The lordship will find that there is a list of grounds upon which.
But on the date you suffer from jaundice,
No,
how
no.
can?
No.
Huh?
No, my lord.
What no?
I haven't suffered from jaundice.
You did not suffer from
Yeah.
jaundice. How is it to be found out?
It was
111.
18 10/24 and 1/11/24 RME report 1/11/24 and 11/11/24 I was examined by the civilian doctors. They found that no jaundice.
Thereafter, no.
1/11 and 11/11, 10 days.
Yes.
Page 55 is DME, page 56 is RME, and then page 57 is the advice slip of the Fakhruddin Ali Ahmed Medical College and Hospital. And the lordship will find this blood test report at page 58. The bilirubin, every type of bilirubin is within the range. And the opinion of doctor is at page 59.
What is the last line?
At which
Why no type copies are here? How have you filed it without producing type copies?
I'll read out, my lord.
You will read out is okay, but as far as the procedure is concerned, type copies were required to be done.
Medical documents are not always required to be.
Read out.
But this certificate at page 59, my lord.
Last line.
Okay.
Second last line.
So, jaundice is within normal limit. His color of conjunctiva may be congenital. As such, he is fit for duty as on today.
What is the meaning of that?
This his eye color, the white of the eyes, is called conjunctiva.
Who is he?
This is
Superintendent.
yes,
Is he
business
an eye
subdivision civil
specialist?
hospital.
Yeah, he has to be an ophthalmologist to give that report.
No, my lord. The bilirubin is
Bilirubin may be different, but
The color of the eye.
the doctors have rejected him. But at the time of rejection, you did not conduct any blood tests.
You conducted lordship. As per this lordship it was.
What does it say?
At the time of detailed medical examination, jaundice present. Review medical lordship. This is the investigation carried out at composite hospital.
What does it say? Medical blood test.
Yes,
Blood chemistry.
yes.
So what is the finding? You read out and tell us.
That lordship,
Does it reflect presence of?
bilirubin lordship.
What is the counting?
Four, minimum is 0.221 mgdl. It was 4.
total bilirubin. So here it shows 1.3 maybe.
But at that point of time, it was 4.
On which date the test was done?
It was done on lordship 29/10/24.
29/10. You have done it after 10 days.
Yes. For 10 days.
You should have done it on the same day. Or one day after.
Then only can contradiction will.
How now this can be?
But moreover, my lord, this is not a ground there in the guidelines. There is a list of grounds for rejection, and among them, jaundice is not one.
I think jaundice is not.
Where is that list?
This is this internal page 7. Paragraph 6.6. There are 29 grounds given there. Jaundice is not one of them.
Where are the grounds for rejection, Mr.
Lordship in page 60,
Roy?
page 63, Lordship, we have.
63 of?
Affidavit in opposition, Lordship.
Affidavit in opposition. Yes.
B, Lordship, that that during review medical examination after biometric confirmation of the identity of the petitioner, he was undergone pathological test and
No,
his-
this is what you've done, but
Done.
we want
Thereafter,
to show
Lordship.
as per the guidelines, where is it?
Lordship, thereafter we have stated Lordship.
Hmm.
And, clinically examination is also done by the board where the doctor observed both BL eyes yellowish color, hence he was declared as unfit in CAP recruitment need diseases free candidate. Jaundice is a condition where there are high levels of bilirubin in the blood. In an army or a soldier is always busy and has to do difficult tasks to be performed. Jaundice makes them feel tired and lethargic, which is not good for a soldier. Moreover, recruitment guideline para 2H page 4 says that the human body may contain so many deformities that it is not possible to list all the causes of unfitness in the medical recruitment instructions and that may mitigate against efficient discharge of service. Neither is it possible to list all trifling cases where the candidate may be accepted or rejected. Therefore, the recruiting medical officer need to be use his clinical acumen to best of his knowledge and keeping in view of the best
No, but
interest. of-
jaundice,
What is it? Jaundice.
unless you arrive at a finding that, no, this is something chronic or it has
Yes.
affected his
Yes.
internal capacity, or you say that no, because of the jaundice, he'll not be able to attend the training for 2-3 months or 6 months. Some finding is required.
Lordship, this was our ground for rejection of the.
Rejection we have seen. Where in the guidelines do you show that supposing somebody is having a high fever on the day of selection,
That's why, Lordship, the
he or she
medical,
will be rejected?
that was not there as per that, all the diseases we cannot include, Lordship.
That's right.
That's why the medical officer who is examining is the best person as stated medical officer. And
But that we are now trying to scrutinize, so he has to be, or you have to convey and place it before us in a manner that it is possible to understand that there is no superficial rejection.
At the point of time that day, Lordship, when his examination was done, he was suffering from jaundice, Lordship.
But that's why
Which
there
makes him
there should be a
unfit, Lordship.
finding that it is chronic. Because it is like fever, my lord, jaundice. Sometimes somebody may suffer and get cured. If it
That is
doesn't,
your bad luck. What to do? What to do?
so if I am not having jaundice now,
Let me
then I am eligible.
let me give you a very let me give you an example. Your candidate is going to the for medical examination. Just at the entry, he falls down, trips, and breaks his head. Will he be considered fit? Will require stitches and so and so. What would be the situation like that? Just a case of bad luck.
But in,
You happen to suffer from jaundice. Bad luck.
but in my case,
You may be ready for recruitment in the next season.
but in my case, my lord,
Unless you show from this that no jaundice or any other disease like that is not a ground for rejection.
since it is not given there in the list
Everything
of
can be given.
in the list of rejection,
It is up to the doctor to decide
yes,
whether you
so
be able
there should be a finding as to how what type of jaundice is this and how it is
No. How
impeding
can
in
there be a
festivities
type
and
of jaundice
training.
giving you all these findings? They are not there to evaluate your health. They are to examine and see whether you will be fit to get into the service. That's all.
And also the contrary findings is there.
The contrary finding will be there on some other day, 10-15 days later if you go. On the same day, 24 hours, 48 hours, if you have taken a finding, then things would have been different. You waited for 10 days or 11 days.
But you also may consider that the doctor opined that the yellow is
but not by
congenital.
How?
The coloring of it.
How?
By clinical examination.
How? Is he an ophthalmologist? No.
No, but
Then he is giving his suggestions.
Yes. Yeah, he says maybe congenital, but this is an
I'm
opinion.
tempted to issue notice to such doctors and refer them to the higher authorities to review their licenses. How can he give an opinion and look at the manner in which he has given this opinion, to whom it may concern? Beyond that, we don't want to say. So what is to be done here? You can show us that no, this is not a ground for rejection on the face of it.
Yes. But since the guideline does not contain this
It
jaundice.
cannot contain. It is only a guideline.
Yes.
Cannot contain.
And if it is not chronic, my lord, it is like a fever. It can go and it doesn't
On what
affect
basis?
people
On what
permanently.
basis are you making this submission?
My lord, from the
There is a medical test, medical board held.
My
On a day you presented yourself, you are not found to be fit.
My lord.
Is there any provision to say that you come back after 1 week or 10 days? No.
No, my lord.
Then
But since the findings is not as to whether it is chronic or not.
it need not be. It's sufficient to say that. It's sufficient. Had counsel for parties, petitioner before this court, presented himself in so and so. Upon being for medical examination, he was rejected on the ground of having yellow discoloration of both eyes and suffering from jaundice. Similar opinion was returned by the review medical board. So this was returned on the basis of pathological tests undertaken.
Yes.
Blood tests.
Yes.
Give us the report. So, then at CGC has placed before the court the medical records pertaining to the petitioner, which reflects that the pathological tests undertaken revealed that the petitioner was suffering from jaundice on this date when he had presented himself for medical examination. Stop. This DME and RME was conducted on 1810. 1810.
DME on 1810 and RME on 1/11/24.
When was DME conducted?
1810.
1810.
RME on 1/11.
RME was conducted on 1/11. DME did not conduct medical test.
No.
No.
Huh?
DME not.
No. DME finding is not based on any medical test.
Oh, because DME finding, however, not based on any pathological or clinical tests. However, the RME conducted pathological tests on 29/10/24, which reflected on the basis of which the RME returned a finding that the petitioner had been suffering from jaundice. Stop. RMA report is dated so and so. Stop. Subsequently, the petitioner was
Blood tests were conducted on 11/11/24.
presented himself before the Fakhruddin Ali Ahmed College Hospital, where his blood test conducted did not reveal that he was suffering from jaundice. The petitioner has also relied on an opinion rendered by the superintendent of Bijni Subdivisional Civil Hospital to the effect that the color of his eyes, which is yellowish, may be congenital. So, on these grounds, the petitioner has assigned the findings of the DME and the RME, rejecting his candidature. Whereas, upon hearing the counsel for parties and upon careful examination of the pleadings as well as the medical records available, it is seen that the RME, the blood test for the RME was conducted on 29/10 and the RME report was rendered on 1/11/24. However, the petitioner presented himself for tests in the civilian hospital on 11/11/24. Therefore, it is possible that on two different dates, two different medical laboratory findings are possible. Stop. On a day when the petitioner was rejected by the respondent authorities on the finding on the medical report of the RME, there were no separate medical tests or medical opinions available with the petitioner to show that the findings arrived at by the CRPF authorities are incorrect, or at least there are contradictory findings by any other competent authority. So the learned counsel with the petitioner has also not been able to point out that has not been able to place any material to show that the rejection by the RME is contrary to the guidelines or the rules prescribed. So, under such circumstances, this court is not inclined to accept the prayers made of the writ petition. The writ petition accordingly stands dismissed. Medical records placed before the court are returned back to the learned CGC.
29 today.
Yes.
Then 29, Lordship. Item number 29. 20.
What about 26?
25, Lordship. 25 disposed. 25 disposed. 26, Lordship. Here, Lordship, I have not received the records and no affidavit filed. In 29, affidavit is filed.
All right, 26, you're right. The learned CGC submits that the medical records are not available with him, and further, no affidavit has been filed. He therefore prays for further time. Matter stands deferred. Who's appearing? You are appearing.
Okay.
Matter therefore stands deferred to be listed again after 4 weeks.
But may I please
Segregated from the series.
may I please on next Thursday, Lordship, because here no affidavit will be required.
After 4 weeks, yes.
Lordship. May I pray date for that, Lordship?
You mention and get a.
Because now the 2026 recruitment has started.
What about item number 28?
28 already disposed. Disposed. Disposed.
Not recent
Disposed of.
direction, the petition.
After 4. Okay, okay. Okay, then
In 29.
29. Okay.
Lordship will find the review medical rejection report at page 71. The ground of rejection on 2 grounds he was rejected. One defective color vision CP4 and second dental.
71.
Lordship 71, 71.
Yes.
Serial number 3, unfit on account of defective color vision CP4 and 2 dental point 12. Lordship.
Dental
After
point?
being rejected, Lordship, he went to GMCH. At
No, I
the
have not understood. What is the ground of rejection?
Lordship, defective color vision CP4. And dental point 12. As per the requirement, the dental point has to be 14. After rejection, Lordship, the petitioner, he went to Tifu Medical College as well as Guwahati Medical College. Your Lordship will find the report of the Tifu Medical College at page 72. At the top of the page, your Lordship will find color vision normal. Impression eye examination shows all within normal limits at the time of examination. 73 is the report issued by the Guwahati Medical College, Regional Institute of Ophthalmology, issued by Dr. Iku Dutt, Assistant Professor.
74.
73.
73.
3.
Right. Color vision?
Color vision within normal limits. WNL is within normal limits.
Okay.
And 74, page 74, Lordship. For medical checkup for SSC GD job, no ocular complaint. Color vision within normal limits. Now, in respect of the eye defect, the color vision defect, GMCH has found in within the normal limit. And in respect of the dental point 12, at page 75, he went to the Regional Dental College of the GMCH, Department of Oral Medicine and Radiology. Patient has come for regular dental checkup and dental clearance. On examination, satisfactory oral health, and 76, Lordship.
Dental point 14.
14. And that is.
Where is the requirement under the guidelines or rules?
Lordship, it will, in the rules, Lordship.
7K. In the affidavit, in opposition, your Lordship will
Page
find.
was missed out, Lordship. That page number 14 in the guidelines, Lordship.
Page number 14.
14.
1-4.
1-4, Lordship.
Dental points 12.
12.
Then
A candidate will be accepted provided there are at least 14 dental points in his mouth and all teeth must be sound or repairable. Thus, the minimum number of points required in a candidate will be 14. 12 filled teeth will be considered as sound. No point will be counted for artificial denture.
Now, your Lordship may kindly see the rules of the review medical guideline.
Where is it?
Which is annexed with the affidavit in opposition, page number 104. Page number 104. Serial number K, as your Lordship found. For a case of dental point less than 14, OPG should be carried out.
What is OPG?
X-ray. X-ray of the entire jaw, of both the jaws.
Was it carried out?
That was not carried out in respect of the petitioner, but your Lordship will find at page number 76, which was carried out by the Regional Dental College, Guwahati. Your Lordship will find that dental point 14 as per OPG X-ray. So
when was it carried out, Mr.
On 27/12.
27/12. And what about the review medical board?
That was on 17/10.
Yes.
Lordship, this is our review medical.
Was it carried out, this X-ray?
X-ray was not required, Lordship, because that was, we manually we do it, Lordship. This is,
How can it be manually done?
Lordship. This was,
But the important thing is that color blindness is normal.
for dental, Lordship, this was.
What is the meaning? How this calculation has been arrived? What is the meaning of this chart?
That your lordship will find at page number 95 of their affidavit in opposition, how they calculate
Page
the dental
13,
point.
page 13.
95, affidavit.
13 of?
That guidelines, Lordship.
This is also in the affidavit in opposition. Incisors, canine, premolars and molars.
No, that we know, but in the this chart that you have given us,
Lordship.
how has it been calculated? That is not
clear, Lordship. That I have to.
That is not clear.
No X-ray was conducted as required by 7K lordship.
And then you have to decide what to do with the color blindness.
Lordship, in our affidavit, Lordship, page 83, the medical, we have specific medical standard question. The report of the Diffu Medical College and Guwahati Medical merely state that the petitioner color vision is normal. However, they fail to specify the exact classification of color prescription CP1, CP2, CP3, CP4, or CP5, which is essential for determining the eligibility under CAP cap recruitment. Page 83, second.
But that even you have not given it in your reports.
Lordship, that was there, Lordship, in our medical report, it's there.
They determined the petitioner as CP4, which is the worst case scenario in a color blindness case.
We have done.
May I humbly submit that the requirement of required standard as per the CRPF is CP3. Now the report of the GMCH and the Diffu medical doctor says that it is within normal limit. Now even considering that they don't specify which one is exactly the color blindness, which is within the normal limits.
It's not here. Have a look.
It has to be either CP1, CP2 or CP3. When the required standard is CP3, so they has to conduct a remedical examination to find out the actual deformity.
Question.
It's not here.
It is defective due to cardiac CP4. CP4 handwritten is there, Lordship.
No, the clinical
findings that
test reports, etc. will have to be there.
Only this was there.
CP4,
Lodge.
it is given CP4.
Lordship, that is also in the review medical report also. I am not disputing that. Their review medical report says CP4. But my report before the GMCH and the Regional Institute of Ophthalmology of the GMCH and the review medical college says that it is within the normal limit. It cannot be CP4 in view of the reports of the civil doctors of GMCH and review medical college. Though they may not have
What is your, how have you responded in your affidavit?
Lordship, page 83, Lordship. Page 83 is second point. The report from the Defoe Medical College and Guwahati Medical College merely state the petitioner color vision is normal. However, they failed to specify the exact classification of color perception, that is so and so, which is essential for determining the eligibility under CAP recruitment rules.
Yes.
Lordship, in my respectful submission, though the report of the GMCH and Defoe Medical College did not specify, but the required standard is CP3. Now, when it says, the report of the civil doctor says that the color blindness is within the normal limit, it has to be either 1, 2, or 3. When the requirement is 3, Lordship.
That presumption, how can we draw?
No, that is why reconsideration is required.
No, then you get a reconsideration from the private medical colleges, government medical colleges. The CRPF authorities have already given a finding that you fall under CP4 category. The contradictory medical reports according to you says you're normal, but doesn't indicate under what category.
That I understand, but when the required standard is CP3, so therefore CP4 is not applicable.
That we don't know.
But that is clear from the reports of the civil doctors. Because they say that their required standard is CP3. Had the report of the civil doctors said that it is CP4, then it would have been a different case.
Color vision normal.
Exactly.
What is the normal range?
CP3. That you also will find that.
Then what is CP1 and CP2?
6.
Below normal.
And then in guideline to discipline
Relying only on Google is going to be dangerous.
No, that CP1 and CP2, that
dangerous. Don't do that. You come back next week, we'll see.
But otherwise,
find any authorities to show what is CP1, CP2, CP3.
Next Tuesday, Lordship.
All right, Tuesday.
If I may pray for F2, Lordship. This is the last case for the review medical board.
So there are 2, 3 others.
Others are also
Only
there,
2 others.
but it was not listed, Lordship.
You wanted on 16.
Lordship.
No, 16. It's on 16th. At the request of the Learned Council for the Protection.
May I pray for taking this matter at 2, Lordship?
You mentioned in 16 morning.
Lordship.
Why do you want everything on orders?
Lordship.
You mentioned it in your report.
I have posted.
31.
Yes.
Hello. Here, Section 30 of Assam Rifles Act, my lord, that is fraudulent enrollment. That
What do you say with regard to the judgments referred to?
judgment, my lord, in para number 7, my lord, of the judgment. It's para 7, page number 5, my lord.
We want to know what is the relevance of section 30
30.
and rule 22.
Yes.
What is the relevance?
My lord, section 30 is that, my lord, fraudulent enrollment. Any person subject to this act who knowingly attempt to get
We have read the section.
Yes,
We are
my lord.
asking you,
Yes, but my lord, here
how do you interpret? How do you correlate?
here, my lord, section 30 is regarding the fraudulent enrollment. Here, the section 22 is giving the false document at the time of enrollment,
What
my
is
lord.
fraudulent enrollment?
Fraudulent, my lord, that is the condition of the section 30 condition of enabling him to be enrolled. But here that from their own affidavit, affidavit in opposition, affidavit in reply admitted that the second, which is required, the qualification is not subject matter here, my lord. What is the qualification fraudulently enrolled or not, my lord? Here the subject matter is the giving the false document, my lord. That is section 2.
False document to justify that he is qualified,
Yes, my lord.
right?
Yes.
So ultimately, it leads to recruitment.
No, that is not needs to be. Kindly come to page number, please. Page number 23. Here, my lord, producing false document, and that is the letter from the department to the petitioner, my lord. You got
Page number?
Page number 25, 23, my lord,
Of
my affidavit in opposition, Annexure 5.
yes.
You got enrolled as so-and-so in Assam Rifle, posted in from the Assam Training School, Limapur 7. You have produced the
So you
provisional
have
certificate.
proceeded by saying, referring to enrollment.
Enrollment, but my lord, you have produced the provisional certificate of high school living certificate. So high school living certificate, that was that is the fraudulent fake document, my lord. That is the difference.
We have understood the case.
Yes, my lord.
We are asking you what is the relevance or the correlation between section 30 and 22.
20.
You are saying that they operate on two different circumstances.
Yes, my lord.
But essentially, the question would be that he had submitted documents
Yes.
to justify that he is otherwise eligible for recruitment at the time of recruitment, which is 9 years prior to his dismissal. Right?
Yes, my lord.
This is not a case that he submitted false medical documents to take medical leave or anything like that. Not that.
That is not the qualification. That is, my lord, provisional certificate, my lord. The false document is the provisional certificate.
For
my lord.
what purpose?
For the enrollment, my lord.
Enrollment is what?
In Assam Rifles, my lord.
Exactly. This is what section 30 is all about.
And section 30 is that, my lord, that is a criteria of, my lord. That section 30 says about the any condition to fulfill the that is not a condition. That provisional certificate is not the condition. He himself admitted that he has already passed the required qualification. He possesses the required qualification, my lord. That is the difference between section 28 rule 22 and section 30, my lord. One of the certificate is, my lord, was the submitted on the time of enrollment is false, my lord.
Right, we'll keep it next week. We'll see what orders we can pass Tuesday. It's not Tuesday. What time? 4:45. Yes, yes.
Next week, my lord, 15 of 15?
15, 16.
16 months.
16.
16 months.
Huh? 16th. 16 December.
16 I'll not be available, 17 man,
18. Hearing the 18.
not 18 hearing.
18 hearing.
Friday holiday.
All right, 18th.
18.
18.
Master blast.
19.
19.
Yes. Date, you have it in January? Right, item 19 to be listed in January on a date to be fixed by the registry.
My lord, in item 14 also we have some urgency, my lord. Can it be on 6th of January, my lord, Tuesday, my lord? 6 or 8 of January? Thursday, my lord.
And my lord, in item number 15 also, same prayer, my lord. In item number 15 also, same prayer, in any date in January also.
All right, 8th of January.
Yes, my lord.
Item 14 and 15.
Public.
Yes,
In item number 18.
item
18.
18.
May I pray for a date after Bihu vacation, lordship, on 27th of January.
Or 27th, okay. Item
18.
18, 27 January.
Much obliged.
My lord, item number 12. I'll take it after view vacation.
Why, what is there in item 12? Who's there? Who's for the respondent?
Lordship, it pertains to disciplinary proceedings.
Hmm.
We have records were called for wherein Mr. Kumar has submitted that inquiry report was not furnished to the
Then
petitioner.
we'll have it on Tuesday, 16th. 16th. 2013 matter, we don't want to defer it that long. 16th.
Item 31 is part 100.
Huh?
Item 31 part 100. That one